Dạ. माइलॉर्ड, माइलॉर्ड हाईवे कॉर्पस माइलॉर्ड 16/7 जुलाई को लगाया था माइलॉर्ड। हाईवे कॉर्पस लगाया था माइलॉर्ड। 16/7 जुलाई का आदेश हुआ था कि नवाई लड़के हैं माइलॉर्ड, वो वन स्टॉप में रखने के लिए आदेश हुआ था 16/7 जुलाई 16/7/26 को माइलॉर्ड। तो मीडिएशन सेंटर में हुआ था माइलॉर्ड। आज के लिए कर दे माइलॉर्ड, कर दे, छुट्टी हो जाएगी। वो घर जाने के लिए तैयार है लड़की। वन स्टॉप हाईवे कॉर्पस माइलॉर्ड। जी मैडम। रजिस्टर्ड है
आज लिस्टेड है क्या केस?
रजिस्टर्ड नहीं, लिस्टेड है आज।
नहीं, लिस्टेड नहीं है माइलॉर्ड। आज में कल से छुट्टी हो जाएगी माइलॉर्ड। वो उसमें काउंसलिंग हुआ था माइलॉर्ड, तो घर जाने के लिए तैयार है। वन स्टॉप का आदेश है कि उच्च न्यायालय का आदेश है कि हम 3 महीने रखने का आदेश हुआ है। वो जाने के लिए तैयार नहीं है।
Lordship, if I may please, I would like to make a mention in a PIL, Lordship, wherein, Lordship, the event is going to take place for today itself, Your Lordship. Lordship.
But I'm praying this matter passes, my lord, may keep on at 2:30. The police has located the corpus, my lord. My lord may take this matter at 2:30. Yes, yes, ma'am. We are grateful.
But in serial number 2, I'm praying for the Passover, my lords.
But in this case, there's a.
My lords, I'm praying for the Passover in this. My lord, my apologies, the seniors only.
Your Lordship, 2.7 is wrongly listed. It's a writ appeal challenging the order in the case of Ram Navesh Patelia.
Madam, and also 2.6, madam. It is a.
6 should be heard by a single.
Yes, madam. Other than other connected 6 writ appeals, 2.6 and 7, they have been incorrectly linked.
Item number 3,
Lordship, kindly pass over, Lordship, prime time.
I'm praying for Passover.
My lord, the writ petition was filed challenging the order passed by the election tribunal whereby my election on the post of member Janpad Panchayat. That was set aside by the tribunal, election tribunal on the ground, my lord, that as per rules 31A of the MP Nirvachan Niyam rules, my lord, the information regarding the pendency of criminal case against me, that was not mentioned in the nomination form. That was the ground, my lord, on which that petition, my election petition was allowed against me, one. And the writ petition has been also dismissed, my lord. Now, my lord, I took a ground, my lord, specific ground, my lord, that as per section 122, my lord, specified officers are defined, my lord, against whom the election petition shall be filed, one. Thereafter, my lord, as per the rules, my lord, that is the rules of 1995 that deals with the disqualification, corrupt practice or election petition rules, my lord. There is a provision that the specified officer shall conduct an inquiry. It's a mandatory provision. And he did not do so.
What is required when there is a fact?
No. My lord, criminal cases were pending. I was acquitted. I placed it on record, my lord. My lord, I took a ground, my lord, categorical ground, my lord, that as per section 30, my lord, section 21 of the rules of 1995, my lord, the specified officer is required to conduct his own inquiry. Now, what he did, he cannot subdelegate the power to the subdivisional officer, my lord, and that he did so. If my lord come to the impugn order, my lord, that was the subject matter of challenge and writ petition. My lord, I just come to that, my lord.
But you left all the column blank.
My lord, my lord, with due respect, my lord, if I go on that, my lord, I'm out of course, my lord, and I argued that also. I was on the point, my lord, that law provide anything to be done in a particular manner, it had to be done that. once there is no power to sub-delegate. Well, intention has to be, but there is no power vested with the specified officer to sub-delegate it. And that was done. My lord, come to the impugned order, my lord. That's, my lord, annexer P4, my lord, of the writ petition, my lord. It starts from page number 44, my lord. My lord may come to page number 45. And I'll, sir, it is dated 9/12/2025. Then my lord may turn to page number 46. Bilkul, aap lords may just come down to page number 46. Would my lord get that? प्रकरण में के जांच प्रकरण के संबंध में अनुभागीय अधिकारी राजस्व अनुभाग हनुमाना से बिंदुवार जांच प्रतिवेदन लिया गया. And this, then he has reproduced, some divisional officer has simply reproduced the grounds taken by the election petitioner in his election petition, say sahi hai, sahi hai, sahi hai. Just my lord, this run till page number 51. 12 पैरा का उसने जो प्रतिवेदन था. Just my lord may, I'll not take my lord from that. All reproduction of the ground taken by the election petitioner, 47 से 48, 49, 51 तक पूरा पैरा 12 तक. And then he refers to the submissions made by the party, and then my lord may come to page number 52, my lord. Would my lord get 52, my lord? प्रकरण आदेशार्थ नियत किया गया. ये मैं पढ़ देता हूँ सर. मेरे द्वारा प्रकरण का अनुपत अध्ययन एवं परिशीलन किया गया तथा प्रकरण में संलग्न दस्तावेजों का परीक्षण किया गया, जिसमें पाया गया कि गैर याचिकाकर्ता क्रमांक 1 द्वारा नाम निर्देशन फॉर्म के साथ प्रस्तुत शपथ पत्र दिनांक 4/6/2022 प्रस्तुत किया गया, जिसमें ऋण के संबंध में जानकारी निरंतर प्रस्तुत की गई, जबकि ऋण के संबंध से टी.के. पांडे कार्यपालन यंत्री सचिन सेस द्वारा वसूली किए जाने हेतु तहसीलदार हनुमाना के पत्र जारी किया गया. गैर याचिकाकर्ता द्वारा इस संबंध में कोई ऐसा दस्तावेज प्रस्तुत नहीं किया जिससे ये प्रतीत हो कि उक्त राशि निर्वाचन आवेदन के समय चुकता की जा चुकी थी. आपराधिक जानकारी के संबंध में नाम निर्देशन पत्र के साथ प्रस्तुत शपथ पत्र दिनांक 4/6/2022 में निरंतर बताया गया, जबकि नाम निर्देशन फॉर्म के साथ प्रस्तुत शपथ पत्र दिनांक तक श्री विनोद कुमार चौधरी न्यायिक मजिस्ट्रेट प्रथम श्रेणी हनुमाना के प्रकरण क्रमांक सचिन से विचाराधीन था. या गैर याचिकाकर्ता द्वारा प्रस्तुत नाम निर्देशन फॉर्म के साथ प्रस्तुत शपथ पत्र दिनांक 4/6/2022 में प्रकरण प्रचलित थे. नाम निर्देशन पत्र के साथ प्रस्तुत शपथ पत्र दिनांक 4/6/2022 को दोष मुक्त होने के संबंध में कोई भी अभिलेख प्रस्तुत नहीं किया गया, जिससे नाम निर्देशन फॉर्म के साथ प्रस्तुत शपथ पत्र की अंकित तथ्यों की पुष्टि हो सके. गैर याचिकाकर्ता के विरुद्ध अवैध उत्खनन के संबंध में भी कार्रवाई की गई थी, जो न्यायालय रीवा के प्रकरण. जी, नाउ ही रेफर्स मानो. There was no stay. वो सर उसी दिन रिकॉर्ड बुलवा लिया था और फिर उसके बेस पे बहस हो गई. नहीं, अभी नहीं, अभी वो तो जनरल नोटिफिकेशन होता, अभी नहीं. इसमें सर एक लास्ट कह दूंगा, देखिए फिर ही से अनुभागीय अधिकारी राजो हनुमा के द्वारा प्रस्तुत प्रतिवेदन दिनांक की कंडिका 1 से लगाए अवलोकन से गैर याचिकाकर्ता के द्वारा प्रस्तुत नाम निर्देशन फॉर्म के साथ प्रस्तुत शपथ फर्जी या कूटरची दस्तावेज की श्रेणी में प्रतीत होता है. उसके संबंध में उभय पक्षों द्वारा प्रतिपरीक्षण भी कराया जा चुका है, जिसमें गैर याचिकाकर्ता द्वारा दस्तावेजी साक्ष्य रूप में ऐसा कोई अभिलेख प्रस्तुत नहीं किया गया जिसके द्वारा पुष्टि हो सके. Now, my lord, I am on the ground, my lord, before your lordship. My lord may just appreciate it, my lord. That, my lord, the requirement of law is, my lord, that you have to record a finding that how it materially affected my election of this return candidate. Now, my lord, may come to first that provision, my lord, of which I say that this rule have been violated. First, I'll take my lord to section 122, my lord. Because mere registration of FIR is not a disqualification. And the only thing is that only one case was pending at that time, and I was not convicted in that also. When I first submitted my nomination, all were petty offences. He is a leader, my lord, sub prohibitory proceedings. My lord may come to section 122. 122 of the Panchayat Raj Adhiyam, my lord. Ji, I have uploaded it also. Yes. An election under this act shall be called into question only by a petition presented in a prescribed manner. आप इसमें Roman, Melon may just come to Roman 2. In case of Janpanch Panchayat to the collector. ये मेरे हमारे लिए. Now Melon may see. Subsection 3 says, Melon, such petition shall be inquired into or disposed of within 6 months according to such procedure as may be provided. Now the procedure is provided, Melon, in this rule, Melon, that is called Madhya Pradesh Gram Panchayat. Just a minute. Yes, my lord. Disqualification election petition rules, my lord. My lord, may come to rule 2 sub rule D, my lord. Rule 2D, where the definition of specified officer is provided, my lord. My lord, may see the word mean is used. Specified officer means the officer is specified in subsection 1 of subsection 122 of Act in relation to Gram Panchayat, Janpad Panchayat, and Jilla Plan. So, my lord, the collector only can be the specified officer. Now, my lord, the procedure is provided, my lord, in Rule 11, my lord. Procedure before the specified officer and his pass. Subject to the provision of these rules, every election petition shall be inquired into by the specified officer. My lord, may I appreciate, my lord, shall word is there, my lord. As nearly as may be in accordance with the procedure applicable under Code of Civil Procedure to the trials of the suit, provided that it's only be necessary for the specified officer to make an amendment. No, my lord, I am on this point only, my lord, that the power, it was mandatory for the specified officer to inquire into at his own, my lord. There is no provision left with the specified officer to sub-delegate the power to the subdivisional officer. And, my lord, he simply says, my lord, that these are the findings by the subdivisional officer without recording that how these things are going to materially affect my election. The order was passed. So these are the summation, my lord, that there should have been a specific finding in this regard, application of mind, my lord, as per Kranti Associates, my lord, reasons should have been there, my lord, independent reasoning should have been there. That was not. Otherwise, my lord, on that ground, my lord, rightly pointed on, my lord, that was a fault, my lord, in that. And, my lord, may see the ground for it, my lord, that provision is, my lord, Rule 21, my lord. My lord, I left that also. Grounds for declaring election to be void, my lord, I'll be referring to Rule 21 of the same rules, my lord. Subject to the provision of sub-rule 12 if the specified officer is of the opinion. Now, my lord, may come to D, my lord, 1D. That the result of the election insofar as it concerns return has been materially affected by improper acceptance of any nomination paper. Now, there has to be a specific finding, my lord, in the impugn order passed by the tribunal that how it materially affected. Now, the differences of vote is, my lord, very vast. It's not a case of acceptance also can be a ground. That could be a ground, my lord, but this mandatory provision which has been violated, that was not. Proper acceptance of the nomination. But there has to be founding how it materially affected. My lord, may see, I have filed one document. My lord, let us see that also, my lord, that if I would have disclosed, my lord, my nomination would not have been rejected because section 36 deals with disqualification. It talks about conviction. It doesn't talk about pendency of the case. It talks about pendency of the case. Mere registration of FIR or pendency of case would not be sufficed to debar me from contesting an election. So even if I would have referred in my nomination paper, my lord, that would not have been so fit. So these are the only points, my lord, for consideration. एक चीज मैं आप मेलोड में सी मैंने एक डॉक्यूमेंट लगाया जो दैट वाज पार्ट ऑफ रिकॉर्ड बिफोर द लर्नड रिट कोर्ट आल्सो मेलोड दैट्स मेलोड में सी दैट एनेक्सर 8 मेलोड दैट्स मेलोड एट पेज नंबर 45 मेलोड शैल डिस्क्लोज ठीक है सर जो निर्वाचन रूल्स में इट्स नॉट ए बार निर्वाचन रूल डजंट से मेलोड दैट इफ इट इज नॉट मेंशन्ड देन द नॉमिनेशन शैल बी rejected unless an objection is made. No such objection was made when I submitted nomination. It is on election petition. Sir, एक चीज और देख ले फिर एक चीज और देख ले A2 आप और देख ले. My lord, this was not a case that by mere difference of vote I won the election. It was vast difference vote. Other candidates was also there. So there should have been a pleading also कि इनके सारे वोट इनके पास आ. ऐसे भी कोई pleading. But he has not been declared. No, he has not. But he challenged it. He said कि I may be declared to be elected. नहीं मिला. इतना सबमिशन I leave it to my lord. ये point, my lord. Therefore, at the threshold, absolutely. Therefore, at the threshold, I said, my lord, that if that part is considered, then I am out of the court. But this legal provision, you cannot violate that, my lord. हाँ, एक ही pending था. उसी के लिए मैं कह रहा हूँ. Pending. My lord, nobody objected, none of the, my lord, law provides that even the voters are also, my lord, that is affixed in the rule says, my lord, that it will be affixed in the panchayat portal, my lord. It would be affixed. It's not a case that some secret proceedings are carried. I file nomination, then it is published, anybody can object. No declaration of privilege? My lord, I was resident of the same village, same village के हैं. गांव वाले और भी आके बता सकते हैं. तो हम पुराने, हम ऐसा तो है नहीं, हम पहले भी contest करते.
Why there is no reason to suppress them?
Well, look, even if it was have been suppressed, my lord, then also it would not have been fatal as per section 36 of the act. बस इतना ही है.
समय के वोटर 2011 में कितने वोटर नए आ गए
आगे होंगे वो, पर वो फाइंडिंग भी नहीं है ना सर. That's no such finding is there. These are the submissions. बस वो डिले था, वो सर पब्लिश जिस दिन से हुआ 3-4 महीना पहले, that was closed for अब वो वीक, उसमें डेट से जिस दिन नोटिफाई हुआ है वो हमने लिखी. जी जी. हाई लेवल.
Ma'am, I am for respondent.
Item number 6.
This is a writ appeal. This is a writ appeal. Firstly, there is a hurdle of delay in the way.
How much?
Around 2 years.
Around
2 years.
2 years. What is the reason for
The petitioner is a 95-year-old lady, an illiterate one, who is.
He is contesting or is the power attorney holder is contesting?
No, she has signed.
He has signed
That
for
is-
how much?
Ji.
How much that? Yes, what is the matter?
Lordship, the appellant's husband was a freedom fighter and he was allotted a piece of land. After the directions passed by this honorable court, the honorable court's direction are at annexure P1 of the writ petition. P1 of the writ petition.
That is उम्र में 95 में mixed है.
जी
95 के लिए क्या करना है? Land मिले.
सर डिपेंडेंट्स भी हैं, डिपेंडेंट्स.
Dependent to कोई right नहीं, तो condition भी दी.
Actually,
The court terminus.
the entire exercise is carried out under the Khand 4 Bhag 3 of Revenue Book Circular, wherein Bhumihin people, persons are specifically defined. Their families are also included. What is Kutumb, what is family, what is a Bhumihin person, everything is defined. And
Husband was made to understand that that has been granted or everything is like that.
yes, in fact,
We reverted back to the government after.
I have only 2 submissions in this regard, Lord. First of all, after the death of the appellant's husband, a complaint was made by one relative that the land has to be vested back in the state. Now, on that, when that complaint was adjudicated, the petitioner, the appellant was not given any notice nor any opportunity.
इसको कोई
That-
right-
जी,
he has no right of everything.
And secondly, no such condition is enumerated in the revenue book circular that the land has to be vested back in the state government. There is no, not even a drop of ink is used to prescribe such a condition.
Freedom fighter is अपने material.
And in the entire exercise, she wasn't given an opportunity of hearing. Writ petition का
Some people here, the son requested collector to take back the son.
it's not the son, it's relative. जी.
मेरे दादा जी का.
लिखा है, but sir, Sumit is not the son of the petitioner. They're all cousins.
वो भी legal
That is a domestic dispute which has reached to the house.
collector passed the order on the.
Ji. But the petitioner was not given any opportunity. This is the ground, and second is no such condition is enumerated or prescribed in the revenue book circular that the land has to be vested back. And when the Honorable High Court passed the order, then again there was no such condition. And thirdly, Lordship, the order by the learned single judge is very concise and cryptic in nature. The reply was not filed by the state. It doesn't deal with the aspect of natural justice and the condition imposed.
It means that the government के बारे में बात करती है. Conditional allow. P4 में
P2 clause number 12 में.
P4 का order
कॉलम 12 में उल्लेखित है.
शासन को घोषित कर दिए मैं ऑर्डर के द्वारा P4 के द्वारा. Along with the application for this is one day. I got a application for continuing on the book for volume of the book and 5 years. For over so what comes to so we don't fight on that, but hectare, 200 hectares.
It is wrongly mentioned, it's only 2.00 hectare.
2.8. Under the circular petition 1998. In the Pujam Paira. Was a traditional allotment of the which the land and this one. That's the well. The allotment is like after the test, one of the leaders here made a complaint to the collector that selected everything. That is why this will be the case. Okay. Complaint and what was the conductor without a rejection for the problem. So that's the second question. The land is being perfect.
Is it being discussed?
May it please your worship. By the impugn order, my lord, my registration as a contractor has been suspended and I have been debarred from participating for a period of 2 years, my lords. It's a fresh matter. Now, my lord, initially I had been awarded a work for construction and maintenance of a road, my lords. That road was completed. Completion certificate I have filed as annexure P3. Thereafter, during maintenance, my lords, my contract was terminated and I was blacklisted, my lords. Now that I had assailed in appeal, my lords, and that appeal was conditionally allowed, my lords. That order, my lords, is annexure P5. At page 42, my lords, I am reading the conclusion, my lords. निर्णय प्रकरण के अवलोकन में पाया गया कि संविधाकार द्वारा सुनवाई में समय दिए गए आश्वासन एवं महाप्रबंधक द्वारा लिखित कथन में उल्लेख किया गया है कि पैकेज के मार्ग पर बीटी पैच रिपेयर शोल्डर का संधारण कार्य एवं मार्ग में संबंधित समस्त संधारण कार्य 15 दिवस के अंदर पूर्ण कर लिए जाएंगे। यदि संविदाकार द्वारा उपरोक्तानुसार कार्य 15 दिवस के अंदर पूर्ण किए जाते हैं तो महाप्रबंधक इकाई स्वयं की अनुशंसा उपरांत पैकेज को पुनर्जीवित करने की कार्रवाई की जाएगी। Now, my lords, this issue was with respect to that. The main issue is subsequent, my lord. Now, after this order, my lords, I have completed the maintenance work, my lords, and reported compliance wide annexure P6. I had completed it within 15 days, my lords. Now, that was verified by the department on 22nd January 2025, my lords. That is annexure P7. So I have complied with the condition. नहीं सर, उसके बाद है, इसके बाद मैं आ रहा हूँ सर। वो मैं बता रहा हूँ सर, वो सब्सिक्वेंट ऑर्डर जो है वो सब्सिक्वेंट है, इसके बेसिस पर आ रहा है, मैं बता रहा हूँ सर। इसके बाद सर that road is not the subject matter of this petition. I am coming to that. I am coming to that, my lords. After I have completed this maintenance work, my lords, I reminded wide annexure P8, P9 and P10, my lords, and finally, my lords, that order was recalled by annexure P12, my lords. My lords, I am my lord, just a second. P12 में सर ये my lords, may kindly see, after this, during this period, I had participated in around 9 tenders, my lords. My lords, may kindly see at page 10 of the writ petition and para 5.11. In these 9 tenders, my lords, I was L1 in first 2 tenders, my lords. Now that those 2 tenders now have been recalled on the ground that I had participated during the period of blacklisting. Yeah, this is what they say, my lord. Now that this is the basis for the fresh order for blacklisting. Now that order, my lords, may kindly see annexure P1. The reason which they assign is on page 26, my lord. उपरोक्त कार्यों की निविदा अवधि में आपका पंजीयन ब्लैकलिस्ट होने के उपरांत भी आपके द्वारा निविदा में भाग लिया गया एवं नोटराइज शपथ पत्र भी प्रस्तुत किया गया है, जिसमें आपके द्वारा शपथ पूर्वक लेख किया गया है कि आपका पंजीयन निलंबित ब्लैकलिस्ट नहीं है. दिस माय स्टेटमेंट हैज बीन my lords, may kindly see the statement they have quoted. Tulsi Narayan Garg, son of so and so, the undersigned do hereby undertake that I have no any litigation. This is the statement which they say that I have made a false statement. Now kindly see the requirement in the RFQ, my lord. Next, Kandika 20.8, the bidder should neither be a non-performing party, my lord, this is important, on the date of opening of the tender, nor on the date of issue of letter of acceptance. The bidder shall be deemed to be non-performing party if it attracts any or more of the following conditions in any of the ongoing completed projects. Now, my lord, the 2 relevant dates are the date of opening of tender and the date of issue of letter. Both these dates in all the tenders are subsequent to my order in appeal, my lords. If my lords may kindly see once again, para 5.11, page 10, my lords, I have quoted the dates. In all, in the first 2 in which I have declared L1 or all others, the dates were subsequent to the date on which my appeal was allowed, annexure P5, that is 20th October 2024, my lords. All these dates are subsequent. Their clause itself says I should not be a non-performing party on the date of opening of bid or on the date of issuance of letter of acceptance. Both dates are subsequent, my lords. And the statement in the affidavit which they have quoted, it also does not say that I have not been blacklisted. Out of 2 years, my lords, more than 1 year I have already suffered.
And what happened to those in tender?
Both have been recalled, my lords. They have issued fresh tenders. My relief is confined to this debarment, my lords. Bank guarantees have also been encashed, my lords. So I have suffered sufficient punishment.
This order is applicable. In line with the, under that, blacklisting policy. Earlier also you preferred an.
But this is suspension of registration, my lord.
Punishment आपको blacklisting ऐसी आ रहा है. और ये है, this is what?
EW.
EW.
The language in this impugned order is suspension of registration and debarment in participation. Earlier it was blacklisting.
Well, it's,
After 2 years, we suffered.
the petitioner had clearly not disclosed with regard to his blacklisting, Millet, and
So are you paying for reduction of period?
When rejection?
Are you paying for reduction of period from 2 years to 1 year?
If my lords are considering that, I'll accept that much. In fact,
But the stigma will not go, otherwise you will be treated as blacklisted for 1 year.
my lords. In fact, I have challenged that both these grounds do not exist. Neither the statement says that I am not black. My lords.
Department order was department. Also, part of the difference in the out of 2 years, the petitioner has already suffered 1 year of blacklisting. Therefore, in two order.
Much.
Which one cover? Yes, upon service. Petitioners का कह रहे थे लेकिन कॉस्ट ऑफ
सर वो लेडी जो है बरामद हो गई थी सर।
आपका क्या
Lady-
रिलेशन है?
जी सर,
टीचर का क्या रिलेशन?
पेटिशनर हम
क्या रिलेशन है इसके?
पेटिशनर का फादर है सर लड़का। यस ठीक।
Your Lordships, I'm praying for a Passover in this matter.
My lord, in this matter, the petitioner has filed rejoinder yesterday only. We wish to go to the rejoinder. Yes, my lord.
Application भी है for improvement of necessary parties.
R1 को sir remove.
वो एक
और remote-
application आपने लगाई है, एक मैंने लगाई है कि ACC को ही पार्टी बनाना था लास्ट टाइम ऑनरेबल को।
जी जी।
Third one, I use the floor. One member. The call that by the process is there. Service will be able to respond. Then we will.
My lord,
Any working actually. We can apply the result. Yeah.
But there is,
reply has been filed by you.
we have also filed an application for deleting the name of the respondent number 1, my lord.
Respond number one.
Yes, my lord. उनकी R1. But the secretary has been made party unnecessary.
क्या problem?
ठीक।
रिस्पॉन्ड नंबर 6 बनाने के लिए सर हमें परमिट कर दिया है ACC।
आपकी भी कोई रीजन? ये वर्क को पढ़ लेंगे।
No, my lord, we moved only this application for deal. नहीं,
नहीं सर, इनका रिप्लाई आ चुका है।
हाँ, वो तो देखा है। कल तो आपने रिजॉइंडर किया।
यस लॉर्ड।
ठीक, next.
नेक्स्ट इज वन एनी बी कमेंसिंग में काइंडली रिमाइंड।
ये वो प्लेटफॉर्म
यस यस
जी।
कॉल लूटिंग।
But we have already filed reply, my lord. We have said in our reply that this is a temporary arrangement. My lord, and so far as we are making some alternative arrangement, my lord, which will be completed within a period of 1.5 years, my lord.
1.5 years.
Yes, my lord, because some other arrangement is being made, my lord.
But why you permitted the company to dump the whole platform?
No, my lord, only uploading is taking place, my lord.
Yeah, that platform can be used for that.
My lord, there are two platforms, my lord. Only 741 passengers come and go from that platform, my lord. And the other platform is being used, my lord, for this purpose temporarily, my lord.
Why permit a platform for public?
My lord, they have filed rejoinder, my lord. And the newly added party is also required to be heard, my lord, in this matter.
They are doing on your permit?
Yes, my lord, we granted them permission, my lord. We granted.
Charging any extra rent from them or free of cost?
No, my lord, after charging the rent from them.
But the public platform का अभी बहुत बोल्ड है।
मतलब 3 माह के लिए परमिट किया था टेम्परेरीली और 3 इयर्स हैज गॉन।
उस प्लेटफॉर्म पे इतना, क्योंकि कुल 8 ट्रेन आ रही हैं वहां पर। जी
सर, मानव जीवन से ज्यादा रेलवे को पैसों की जरूरत है सर। मानव जीवन से ज्यादा रेलवे को पैसों की जरूरत नहीं सर। उन्होंने अपने रिप्लाई में लिखा है कि जो पैसेंजर से जो अर्निंग हो रही है वो 16,48,000 लिखा है सर, और जो लोडिंग से हो रही है वो 26 करोड़ 48 लाख हो रहा है।
मलट में टेक मलट में जी जी रेलवे जी
वो तो रिमूव करिए वो जनरल पब्लिक ये तो इमीडिएटली करिए
जी
This petition is regarding the transition period of the GST. We have some contracts were allowed, was given to us in the VAT period, and they have traveled through the GST period. So we are, as the rate of taxes of GST has been enhanced, so we have, we tried to make applications for the higher rate to get the higher rate from the departments, but they are refusing to give the same. That's we have filed in petition regarding the same. And some similar petitions are also there, sir. Tag to WP number 16860 of 2018. Bunch of petitions are there. हाँ जी, नहीं सेम नहीं, सेम नहीं है सर। GST, हाँ ये सर GST में जो रेट ऑफ टैक्स चेंज हुआ था गवर्नमेंट कॉन्ट्रैक्ट्स पे फ्रॉम 12 to 18, तो उसमें सर हमने हमारे कुछ कॉन्ट्रैक्ट्स थे दैट वर रिलेटेड टू द प्रायर पीरियड, और वो ट्रैवल करे थे मैंने विद फॉर द हायर रेट्स। हाँ उसका अलग बंच है सर, P4 जी।
May it please your lordship. But P6 is under challenge, whereby my contract was terminated. The contract was with respect to the sale of the harvested fish in the Bargi Reservoir. In fact, it's a second round of litigation. In the first round of litigation, my lord, we have specifically requested from the Honorable Court that we are ready to pay the penalty amount. However, the order was is at page P6 is the impugned order. P6 is the impugned order, my lord. Clause 14 of my contract agreement specifically says that the power vests with the Mahaprabandhak, and the contract was terminated by the Kshetriya Prabandhak. So the competence is under challenge, madam. P6, page 58, 59. Sir, my lord, may kindly appreciate. Prabhari Kshetri Prabandhak is the authority. Page 58, last. And my lord, may kindly appreciate the contract agreement. Clause 40, page 36. My lord, may kindly. My lord, we did not deposit, my lord. We say, we have specifically made a request that we are ready to deposit the amount, my lord. Though there was delay. 45, my lord, the. 10 days then, despite that. My lord, we could not, my lord. May kindly appreciate. My lord, the competence and the jurisdiction of the authority is to be seen, my lord, if your lordship may consider. My lord, certainly, my lord. It is, my lord, certainly. Yes, your lordship may. Yes, my lord, may kindly appreciate page 11, P11 for a moment. P11, the earlier round of litigation. P11. It is at page 65. 65, my lord, may kindly appreciate. There is a consideration. My lord, they did not consider it, my lord. They did not. In fact, they filed a review petition saying that they were not the party and contract was awarded to some other person, the private respondent. But this review petition is pending. Then my lord may fix any week commencing, my lord. Any week commencing in September. Could it be slightly earlier? No, sir, slightly earlier. I'm grateful.
What's the paying for Pashuva?
Yes, the petition has been blacklisted for a period of 1 year by the impugned order dated 13/7/26, that is election P8. P1. P8. P8 at page 67. this order has been passed by the chief engineer of urban administration and development department. Now, my first submission is not that this authority has no, this officer has no authority to blacklist because there is no contract with this respondent number 3. My contract is with Nagar Palika, if the lordship may kindly have a look at the tender. The tender was invited by Nagar Palika, the letter of acceptance was issued by Nagar Palika and the agreement is also with Nagar Palika. Now, as per contract data, the employer is the Nagar Palika, it is only the Nagar Palika which can take action. Now, this chief engineer he is the appellate authority as per the contract. He has no authority to directly pass an order not against us.
Nagar Palika is only implementing agency of this point.
But the privilege of
They are funded and monitored.
funds is provided by the central government, that is true. But the employer ultimately is the Nagar Palika. Otherwise, not the state government. Agreement is with Nagar Palika, letter of acceptance is by Nagar Palika. Though the funds is provided by the central government, not under Amrit Yojana. But the implementation
Is dated 4/8/25, only 3% work has been done.
yes, the reason is given, not if lordship may kindly have a look at the reply. This is not a contract related to providing sewage related services. Now for sewer related services, first they have to identify where the STP, that is the sewer treatment plant and the pumping station will be constructed. Thereafter only, I can start the work of laying sewer line. Till date, they have not identified where the sewer.
How he put the rate without the identification of place and without measurement and without everything, without seeing the site?
That is given in the contract. But the location of the sewer treatment plant, demarcation,
Location is not important to decide the rate.
yes.
How is it error?
So that is not be given in the contract. That how much is the length of sewer lines, how much STP is required to be constructed.
After visiting the site,
Your lordship may kindly have a look at my reply. My reply is very specific. Your lordship may kindly have a look at my reply. That is annexure P7. Your lordship may kindly come to page 16. Now, this is a technical aspect which is required to be looked into by the authorities. Page 64 may kindly be, this is my total data. Until and unless the sewer treatment plant site is identified, demarcated and handed over to me, I cannot commence the work of laying sewer. Your lordship may just have a look at 2 paragraphs. That will make my case clear. Page 64 top 2 paragraph. वास्तविक स्थिति है कि दिनांक आज दिनांक सीवर सीवरेज उपचार यंत्र एसटीपी तथा इंटरमीडिएट पंपिंग स्टेशन स्थलों का सीमांकन सहित औपचारिक हस्तांतरण एवं अति कब्जा विभाग द्वारा उपलब्ध नहीं कराएगा, जबकि निविदा शर्तों के अनुसार यही समय डिजाइन निर्माण गतिविधियों की मूलभूत शर्त थी। भूमि उपलब्धता के अभाव में परियोजना की प्रगति सीमित रहना स्वाभाविक है तथा इसे ठेकेदार के दोष के रूप में नहीं देखा जाता। नेक्स्ट पैराग्राफ इज वेरी इंपॉर्टेंट। निविदा प्रावधानों के अंतर्गत औपचारिक भूमि हस्तांतरण के अभाव में इस चरण में केवल टोपोग्राफिक सर्वे एवं प्रारंभिक स्थल सत्यापन ही अपेक्षित था। भू तकनीकी जांच, नेटवर्क डिजाइन का अंतिमकरण, पीईटी, प्लांट लेआउट अथवा अन्य किसी प्रकार का भौतिक निर्माण इस अवस्था में न तो तकनीकी रूप से संभव था और न ही अनुबंधित रूप से अनिवार्य। Now we cannot ultimately it is sewer line. The gradient is to be decided in which direction the sewer will flow. Yes.
How
Because the entire action has been taken at Bhopal. My employer has not taken any action. The order implemented.
location of the work is situated?
But it is not connected with the work. It is an action which has been announced has been taken by an officer stationed at Bhopal. But there is direct division bench judgment if the order is issued from Bhopal and no action has been taken at Pithampur, therefore this honorable court will have the effect.
No action.
No action.
From your side.
No action by the municipality, but by my employer. Ultimately, entire action has been taken at us. And second reason is this similar action has been taken against 5 contractors. Now, all those out of these 5, 4 contractors, they will file a petition here. Now, the same action has been taken. I have a copy of the minutes of meeting. Now, action has been taken against 5. 4 may not will approve this honorable court. In fact, 1 has already approved, and his petition is listed before single. 2 dates, serial number before single. Now, in case I put in the other petitions are entered in here, then there will possibility of conflict of office.
Why single this?
But they must have
Only
been
blacklisting matter.
Yes.
It's only blacklisting.
That Also contract value disclose करनी पड़ती है इसलिए हमने contract value disclose. Otherwise not settlement cannot be. उसमें भी contract basis ज्यादा ही है. Whether the petition is no, whether counsel for नहीं ऐसी गलती नहीं कर रही दोनों एक सी शो कर The contract has not been terminated. No, contract has not been terminated. We are proceeding with the contract.
Well, it's 3% work in
But without termination of contract, how the blacklisted will work?
Well, it's to ensure that further more work is not disrupted.
We करा देंगे.
2 साल में सर सिर्फ 2
साल में
contract है, 1 साल में
4/8/25 का तो एग्रीमेंट है और जनवरी 26 में उन्होंने नोटिस भी दे दिया और एक्शन लिया अगेंस्ट नॉट आफ्टर 7 notice was given in the month of January 29/1/26 within 5 months not they gave this one and now not they have waited for 7 months and now they have issued this term yes blacklist amount.
समीक्षा बैठक में तो समय भी दिया गया thereafter also there is no 23 25 2026
Clause 24 Roman 2 yes of PL4 contract corrupt practice. Not my submission, it will not fall under any of these categories. Power we give it to the state government. 24(3)(2) Roman 2. Yes, sir. They debar the bidder if he is being blacklisted by any department of state government or government of India for non-performance standard execution or any other. But this is an eligibility condition that I should not be debarred by any department of the state government or government of India. This does not empower the state government to debar. It only says that if he is being blacklisted by any department of the state. This empowers the law for debarring on the ground of corrupt practice or fraudulent practice. Now, this is not a corrupt practice, this is not a fraudulent practice, but that is also defined. Fraudulent practice, corrupt, coercive and collusive practice, that everything is defined. And it's similar, clause 24 starts with employer. Employer, if you lordship is contract data. Contract data is at page number 53. 53, employer is Nagar Palika Parishad and appellate authority is chief engineer, engineer in chief of fluid. And so for delay is concerned, not for delay, they can impose liquidated damages. That provision is also there in the contract. That they are not doing. Directly may not the petitioner has been blacklisted. For liquidated damages, not they have to show that the delay was on my part. Lordship may see my entire reply. My entire reply is that not in the absence of SPP, handing over the site of SPP, I cannot comment the file. Still not I comment it. Still I comment the file at my own risk and cost. Annexure P7 again the kindly listen. The entire stand is this. And there is no consideration of my explanation for the absolutely not, it's a non-speaking. reference may come to reference, page 52. विभाग को प्रेरित पत्र एचटी अपने स्थानांतरण हेतु पर दिखाए जाने हेतु फिर वर्क बेस वर्क प्लान where are these all being documents?
Which one? But we have a copy of the agreement, complete agreement. Put in, yes, now.
Any correspondence with your mental hospitals?
No. Lordship may seem not the, after the issuing this order, not they convened a meeting. In that meeting, not the chief municipal officer was summoned, and there they made a complaint, not that the progress is not certified. But this is on 13/8/2020.
So whether the corporation or council is certifying that the site was not eligible to.
Yes, sir. That is an admitted fact of the son.
Minister there.
Municipality doesn't say, my lord, that the site has been identified, it has been handed over. They don't say, even in the impugned order, they don't. When my stand in the reply is that I have not been handed over the site. The minimum which is expected now is to say that this stand is incorrect, the municipality handed over the site to beyond such and such. They don't say.
Involve that. Because the council has, and we have them. Is open to the. Yeah. No.
For 1 to 3 minutes, they have filed period. I have already served the copy. 1 to 3 that they have filed period.
One to three are the state. What is the requirement for four? That the requirement for four is our number. In order to verify the fact that whether the petitioner has been handed over the site. It's wrong. Second purpose. Item number 50.
These are a batch of matters concerning the Competition Act. And with previous date of hearing, you are pleased to pass an order of bearing the matter. And though the reply of the state government has not been filed. In any of the case except item number 15.1. Because that thing is based upon the procedure and the precise policy which has been framed by the state. So what is the stand of the state government? Because they were also, the excise commissioner was also summoned for being examined by the Director General of Competition Commission.
You are telling me the order passed by the respondent.
As such, there is no order which is under challenge. Of course, we have challenged 3 orders. We challenged 3 orders, but our principal submission is that CCI has no jurisdiction to do anything in the matter. And also, it has the power to exercise suo motu, but in the given facts, suo motu power could have not been exercised. These are the two main principal submissions based upon which we have challenged the authority and the very initiation of the proceedings. The scope of the act can be seen in section 3 and 4 of the Competition Act, which provide for anti-competitive agreements and the abuse of dominant position. Excise policy is framed by the state government. The intoxicating liquor falls into the exclusive category of schedule, I would say, this too. And as such, central government has no role to play in the matter. What we have done, we have followed the excise policy.
Start from beginning. First time this matter was coming before for argument. What is the matter? Start from the beginning.
There are about 8 distilleries which are manufacturing country liquor, and they are participating in the tender process, which is conducted by the state government for the purposes of supply of country liquor to various districts, initially 50 districts and 52 districts. The tender notices were published in the years 2012 onwards. The range of the inquiries 2012 to 2017. The Competition Commission has passed the order, initial order on 4/8/2020, Annexure P4, page 510.
You are arguing from WB 138.
I'm appearing as item number 15.2, associated alcohols. WB number is 10304. Associated alcohols. The first petition and point of time was Great Galleon. In Great Galleon, the initial order was passed by this honorable court. We have uploaded that order in associated alcohols at serial number 5 in the reference.
All parties are represented by counsel.
Yes. So far as the respondent number 2 and 3, they are represented through the SGI appearing for.
In the last one, we requested that the matter can be answered by the petition 25th, and then 26th we will answer the matter. But not subsequently, we will follow the petition 26th. While the instruction is not right, the petitioner will continue with the argument and we will answer the next one. But yes, I am representing 20 on the matter. So, competition.
Last order is 6/8/2020.
They are the contestant respondents.
What is the role of state government and central government?
The state government, initially the principal secretary was called by Competition Commission for examination. Statement was recorded to the principal secretary to ascertain as to what is the policy of the state government and how it is violating the act. Initially, notices were issued to principal secretary, excise department and all the distilleries. Later on, when the state government filed the reply that this is the procedure by which we conduct the tender process, they have not been issued notices. They have not been implemented as opposite parties, but all the distilleries have been made opposite parties and notices have been issued and the order has been passed on 4/8/2020. I should not say taking cognizance of the matter, but initiation of proceeding for determination of prima facie opinion of this Competition Commission. An order has been passed on 4/8/2020, issuing notices and asking the Director General to investigate the matter. Pursuant to that, the Director General has submitted the investigation report on 31st of March 2023, Annexure P6. And thereafter, when the CCI has considered the report, it has order for the further inquiry. In the interregnum period, the petitions have been filed, challenging the very initiation of the proceedings by the CCI, as also the report of the directors.
There is a tribunal in this state.
That is the appellate tribunal. The appeal is maintainable under subsection 2, 2A, 6 and 9 of 26. That is clear mention in the act itself. That may not be appealable. No, will not be appealable. I'm going to just read the provisions of the appeal. Never may have this competition. Section 53A provides for the constitution and composition of the product. But we have Section 53A provides for the appellate tribunal. Can you read me? Section 53A. Capital A. The National Company Law Appellate Tribunal constituted under Section 410 of the Companies Act shall, on and from the commencement of Part 14 of Chapter 6 of the Finance Act, be the appellate tribunal for the purpose of this Act, and the same appellate tribunal shall A. Hear and dispose of appeals against any direction issued or decision made or order passed by the Commission under subsection 6 of Section 6, subsections 2, 2A, 6, and 9 of Section 26, Section 27, 28, 31, and so on. So this matter fall into the category of Section 26. And if I read Section 26, these are the 4 eventualities where the final orders are passed, not the other orders. Though when we read Section 53B, it appears that all orders are appealable. I'll just not clarify this point so that later on some may not argue this. Appeal to appeal tribunal. The central government or the state government or a local authority or enterprise or any person aggrieved by any direction, decision, or order referred to in clause A of Section 53A may prefer an appeal to the appellate tribunal. So it is qualifying that part which is provided in 53A small a, that the nature of the order has to fall into the category of subsection 2, 2A, 6, and 9 of Section 26. Now, if I may read below Section 26. 26, 1 provides for the determination of prima facie opinion. I read now Section 26. Procedure for inquiry under Section 19.
Action has been taken under Section 26.
Yes, that is the only charging section of the provision which empowers for holding the inquiry. That's why I'll clarify that. Section 26 may kindly be seen. Because 53A says that the orders have to fall into the 4 categories, 2, 2A, 6, and 9. Section 26, 1 may kindly be seen.
Procedure for inquiry under Section
1. On receipt of a reference from the central government or a state government or a statutory authority or on its own knowledge or information received under Section 19, if the Commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter, provided that if the subject matter of an information received is, in the opinion of the Commission, substantially the same as or has been covered by any previous information received, then the new form of information may be clubbed with the previous information. 2. Where on receipt of a reference from the central government or a state government or a statutory authority or information received under Section 19, the Commission is of the opinion that there exists no prima facie case, it shall close the matter forthwith and pass such orders as it deems fit and send a copy of its order to the central government or the state government or the statutory authority or the parties concerned as the case may be. So this is the first eventuality, that no prima facie case was found. This is the final order. 2A. The Commission may not inquire into agreement referred to in Section 3 or conduct of an enterprise or group under Section 4 if the same or substantially the same facts and issues raised in the information received under Section 19 or reference from the central government or a state government or a statutory authority has already been decided by the Commission in its previous order. So this will also not apply, and this would be a final order. They will not proceed further in the matter. 3. The Director General shall, on receipt of direction under subsection 1, submit a report on his findings within such period as may be specified by the Commission. So pursuant to the direction under subsection 1, the Director General shall investigate the matter and submit the report. This is what 3 says. 3A. If after consideration of the report of the Director General referred to in subsection 3, the Commission is of the opinion that further investigation is required, it may direct the Director General to investigate further into the matters. 3B. The Director General shall, on receipt of direction under subsection 3A, investigate the matter and submit a supplementary report on his findings within such period as may be specified by the Commission. 4. The Commission may forward a copy of the report referred to in subsection 3 and 3B to the parties concerned. I'll skip proviso. Subsection 5. If the report of the Director General referred to in subsection 3 and 3 recommends that there is no contravention of the provisions of this Act, the Commission shall invite objections or suggestions from the central government or the state government or the statutory authority or the parties concerned, as the case may be, on such report of the Director General. Now comes 6. If after consideration of the objections or suggestions referred to in subsection 5, if any, the Commission agrees with the recommendation of the Director General, it shall close the meeting forthwith and pass such orders as it deems fit and communicate this order to the central government or the state government or the statutory authority of the parties concerned as the case may be. This is the third category of final order. 7. If after consideration of the objections or suggestions referred to in subsection 5, if any, the Commission is of the opinion that further investigation is called for, it may direct further investigation. We skip that later part. Subsection 8. If the report of the Director General referred to in subsection 3 and 3B recommends that there is contravention of any of the provisions of this Act, and the Commission is of the opinion that further inquiry is called for, it shall inquire into such contravention in accordance with the provisions of this Act. 9. Upon completion of the investigation or inquiry under subsection 7 or subsection 8, as the case may be, the Commission may pass an order closing the matter or pass an order under section 27 and send a copy of this order to the central government or the state government or the statutory authority or the parties concerned, as the case may be. Provided that before passing such order, the Commission shall issue a show cause notice indicating the contraventions alleged to have been committed and such other details as may be specified by regulations and give a reasonable opportunity of being heard to the parties concerned. So the scope of the provisions enumerated in subsection 2, subsection 2A, subsection 6, and subsection 9 alone talks about the finality of the orders. And from this perspective, section 53A provide appellate remedies only against these 4 exigencies contained in section 26 of the Act. I'll again not come back to section 53A, clause A. Here in disposal.
Then section 26 is the procedure part. And final order is passed under 27.
27.
Entire.
Yes, that is completely final. Completely final. Because section.
Final, so that 27 is there under section 53A. Appeal like
Yes.
the order passed under section 27.
Yes, in this case, this stage has yet not reached. We have approached this honorable court at the stage where the commission has ordered the Director General to investigate the matter. Director General has investigated the matter. CCI has considered that and are ordered for a further inquiry. So we are at the stage of 3A.
It's a premature. The final order is yet to be passed.
That is why we are before this honorable court. That's the very initiation of the powers by the CCI of making a prima facie.
Why we should interfere at this?
Because what has been postulated in section 26 alone empowers the CCI to interfere into the matter. But they have not cared to examine as to what is the role of the other regulator. What the Supreme Court has said in the case of Bharatiya.
It is also this, right?
We have-
Under the 27.
We know 27
When the
was
state come,
20.
then, Tribunal will examine all that.
but before that, in subsection 4 and subsection 3, the CCI has to send a copy of the opinion and the proceedings to us and solicit our objections. That is the stage provided in this act, in this section itself. They can continue or close the matter pursuant to our objections and suggestions.
So matter is liable to be closed only after passing order under section 27.
They have not considered our objections and have passed further order.
If pass final order, then we can say our objection has not been.
But that time, the very purpose of filing this writ petition was frustrated in a way that they have no jurisdiction to interfere in the jurisdiction of the state government. State government is the independent statutory regulator. I'll just not read the provisions of MP Excise Act.
Let the state government say so.
State government has said in the reply that we are.
filed a reply. Our stand is that under the constitutional framework, we regulate the manufacture and sale of country liquor. And there is a policy framed by the state government. And in accordance with the policy, we have identified the bottlers. And the proceedings by the commission are in direct contravention with our power. We have filed a reply, our reply supporting the bill. This is
No,
our stand.
they're supporting the very scheme of the act. You know, there are, in the case of Bharti Airtel, the Supreme Court has said that there are two kind of regulators and there should be no conflict of jurisdiction. The state government is the statutory regulator and they are the market regulator, CCI. Therefore, my lord, they have to see only those aspects which are anti-competitive. Here is a case, the entire Competition Act has been visualized on the issue that there should be a fair and healthy competition in the market. But they always see as to whether it is anti-competition or not. From that perspective, when the state government has said and objected before the Director General that you have no power to exercise.
But actually, to say that the state government was heard.
Yes, the statement of the Principal Secretary was examined. Mr. Mukesh Nima, who was the Excise Commissioner, was called at New Delhi and he was thoroughly examined for I think 2-3 days. Statements were recorded and only thereafter the reply also stated this fact. But they have what they have stated. I will read one of the paragraphs in the DG's report. Director General has opined that it is only because of the policy of the state government that it is appearing that there will be a cartel formation kind of a thing or something which is ununderstandable. I'll quickly come to this report of the DG where he has observed all these things. So, and CCI was not happy with the report of the DG probably. That's why they have ordered for the further inquiry. Now, further inquiry could have been ordered only in the background that some specific issues are required to be framed. If I may read my regulations, the regulations say that unless you have sufficient material, you cannot order for further inquiry. So without saying anything, the further inquiry order was passed. From all these perspectives, my lord.
Matter is that the very preliminary of the stage of 27.
Our remedy. Our remedy. Our remedy. I have two submissions to make. So far as Section 27 stage is concerned, which says orders by commission after inquiry into agreements or abuse of dominant position. Once it reaches the conclusion and we participate in the proceedings, it would be almost acquiescing the entire objections presented before that, because the scope of the appeal is very limited. All issues are not open before the appellate authority. They will say only this: what are the points determined at the prima facie opinion formed by the CCI, on what points the investigation was carried out, what is the supporting evidence, and what is the conclusion. They will not go into the foundational error. What the proceedings have, can we see the proceeding which took place before this on upload in case of Great Galleon? We have uploaded that order, the first order, serial number 5 of the, in the reference.
Order dated 9/2/24.
9/2/24. This is not the first. This petition was listed for consideration of interim prayer on 18/10/23. After the initial order dated 11/10, a prayer was made for interim relief. However, the matter was adjourned for 4 weeks to enable the respondents to file the reply. Reply has been filed. It is primarily contended by the respondents that there is no order as such that has been passed. It is only a proceeding that has been initiated, and if at all an order would be passed, the same is appealable. However, the same is disputed by the counsel for the petitioner on the ground that suo motu proceedings have been initiated, which is impermissible, and furthermore, they are likely to take up coercive measures against the petitioner. However, in view of the contentions advanced, we are of the view that the contention of the respondents that no order has been passed till date requires to be considered. Therefore, we are of the view that it would be appropriate to direct the respondents not to take any coercive action against the petitioner until further orders. However, the validity of the suo motu proceeding requires to be considered by this court. Now, I am on that aspect.
Are at liberty to proceed further. So whether any order in the 27 is passed?
No, not no order is passed.
Because there is no state in that question.
Thereafter, the 20th March order was passed by the Assembly.
P20.
I'm sorry. They have taken into consideration this order in Annexure P13 dated 20th of March 2024 that Honorable High Court has considered this matter, carved out this question for consideration and asked us to proceed in the matter. So a substantive order was passed on 20th of March 2024. I'm open to correction. My learned friends appearing for the respondent can clarify as to whether they have proceeded further or not, because I have not been given notice to appear or to participate further beyond 20th of March 2024. Lecture P13 in my case may not begin from page 1861. Para 13 can be seen at page 1864. May I read?
So after these two order, P12 and P13, now DG is required to lead an inquiry.
Further inquiry.
Further.
And for,
Has it been done or not?
no, not to our knowledge, because no document has been placed on the plot. It is the, but there's a clear order of this honorable court that they can proceed with the matter.
But they have to not to.
Yes. So, Madam, why I'm saying suo proceedings are bad in law? Because if we go by the first order, annexure P4, page 510, which is the suo case, the first order sheet, rather, of the CCI, annexure P4, page 510, the foundation of initiation of the proceeding is based upon report of the Comptroller and Auditor General. Annexure P4, the first paragraph says, the present case emanates out of Comptroller and Auditor General of India report number so and so on revenue sector of Government of Madhya Pradesh for the financial year 16-17 CAG report. A perusal of relevant extract of said report points toward possibility of bid rigging and cartelization and supply of country liquor by distillers to retailers in various districts of Madhya Pradesh during the period so and so. All my lord, subsequent paragraphs, particularly by para 4, observations of the CAG have been recorded. Page number 514, paragraph 8 onwards, the report has been discussed. And lastly, at page 518 in paragraph number 21, it says, accordingly, the Commission directs the Director General under the provision of section 26(1) to cause an investigation to be made into the matter, and thereafter the matters have proceeded. My first submission, the foundational submission on the exercise of the power suo motu in terms of section 19. Section 19 empowers them to exercise the power suo motu. May I read now section 19?
No, this case is related to that year 2016-17.
The CAG report.
Check the financial year 16-17.
Yes. That is the foundation on the basis of which they have decided the check period from 2012 onwards.
So now only the penalty at the rate of 10% can be. But the same system is continuing till today.
State government has not made any change because this is the only things available. And my lord, Supreme Court has said that this is the system which is prevailing everywhere in the world. The word they've used, there are two terms, oligopsony and monopsony. These are the two words which Supreme Court has used in the case of Rajasthan Civil Interest. I'll read out those judgments and those paragraphs, which says that it is the necessity of the market where such kind of arrangements have to be made. I'll just give illustration. There are only 8 or 11 industries.
Let the CCI give you a clean sheet, we can permissible, you satisfy them.
You know, we will do it. What I'm saying that their very initiation of not there is a constitutional say, aspect of this. Whether on the basis of this information, they can exercise the power suo motu or not. That is my first submission, which goes to the jurisdiction aspect. I'm having 2 points to make out. That this is without jurisdiction, And two, suo motu proceedings are bad in law. I'll not make my submission on the jurisdictional part first, if I not say, or the suo motu part. Section 19 may kindly be seen because that is looking more so dangerous. Section 19 says the commission may require into any alleged contravention of the provisions contained in subsection 1 of section 3 or subsection 1 of section 4, either on its own motion or receipt of information in such manner and accompanied by such fee as may be determined by regulations from any person, consumer of the association or trade association. So any person can make complaint or on their own motion they can do it. Now, when we read section 26, the very same authority has been given in subsection 1. Yes. Subsection 1 says on receipt of a reference from the central government or a state government or a statutory authority or on its own knowledge or information received under section 19, if the commission is of the opinion that there exists a prima facie case, investigation can be made. So, exercise of power suo motu requires some information to be gathered from available public sources by the Competition Commission. Here is a case which I want to establish on the strength of Article 151 of the Constitution of India. It begins from Article 149, Control and Auditor General of India. In Chapter 5 of the Constitution. Yes. Under Article 148, the Controller and Auditor General of India is appointed. 149 are the duties. I don't have it. Constitution. Article 148.
I put what constitution now.
That's right. Yes. Article 148 deals with the Control and Auditor General of India as a concept. 149 deals with duties and powers of the Control and Auditor General. It says the Control and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states and of any other authority or body as may be prescribed by or under any law made by the Parliament, and until provision in that behalf is so made, shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states as were conferred on the exercisable by the Auditor General of India immediately before the commencement of this Constitution in relation to the accounts of the Dominion of India and of the provinces respectively. Now comes 151, which provides for the audit reports. My submission, my lord, on the basis of Article 151 is that the procedure says that no sooner the report of the Controller Auditor General is prepared, it is submitted to the Honorable Governor, and Honorable Governor routes it to the Assembly, or Honorable President of India routes to the PSC in the Parliament, and on the recommendation of the PSC or the committees, it is to be decided by the state government whether it has to be placed on the table of the Parliament or the legislature or not. So till the matter is within the province and jurisdiction of the state legislature or the Parliament, the report remains within the internal jurisdiction of the state legislature itself. And because it is not published, it is not a public document, not available in the public domain. So far as this report is concerned, the reply of the state government also clarifies that 2016-17 CAG report is still pending consideration before the state legislature. It has yet not been tabled on the legislature. Now, from this background, Article 151 may kindly be seen. 1. The reports of the Controller and Auditor General of India relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. 2. The reports of the Controller and Auditor General of India relating to the accounts of a state shall be submitted to the Governor of the state, who shall cause them to be laid before the legislature of the state. Now, it is an internal audit report. It is a very peculiar audit report as prescribed in Article 148 and 149. The government wants to see as to whether our functioning is proper or not, as to whether it is as per the business rules, rules of business and business allocation rules or not. And for that purpose, they submit the documents to the Comptroller and Auditor General. They do the audit so far as statistics is concerned, but they also give suggestions and lodge their objections for the improvement of the governance. So that is the additional advantage of the CAG report. And from that perspective, when the CAG makes its report, it is
That is the one more. Second is under section 90.
It was, the question would be whether this is out for public or not. How the Competition Commission of India has got access to this document, which is still in the four corners of the legislature itself. It has yet not been tabled on the assembly. The moment it is presented before the assembly, it is tabled in the assembly, only then and thereafter it becomes public. It becomes a public document only then. Otherwise, it is, I'm not using the word confidential. It may be confidential for the public, but it is not confidential for the state legislature. There they are circulating this, but where comes Competition Commission in the structure of the state legislature? There's no entry, there's no scope. None of the members of the Competition Commission are members of the State Legislative Assembly.
And any person can make a complaint under section 90.
Nobody has made the complaint. That is the case.
So
Had that.
any person, on a complaint of any person, private person, commission can start inquiring that.
I'm good. That had that been the case, I would have not argued this. But where is that complainant? Where is that complaint? Since there is no complaint, this provision would not apply. The provision of suo motu exercise of power would apply, and that is what the CAG has said. The CCI has said in the first paragraph that based upon the report of the CAG, year 2016-17, we are emanating proceedings from that. And they have extensively quoted the paragraphs, recommendations, suggestions, and objections of the CAG. So until and unless it satisfies the requirement of Article 151(2), that it is placed, there is a direct communication. CAG submit the report to the Honorable Governor. Honorable Governor constitute a committee. The committee examines that, and thereafter the matter is circulated. If it is found worthy of circulation, it is tabled on the assembly floor. Before that, nobody can have access to that. So how CCI has got a copy of it? They may have unofficially got that. But in the eyes of law, can they exercise suo motu powers on the basis of the CAG report when the matter is still before the state legislature? Had it been a case of parliament?
And if there is a indication that there is a arrival between companies and the state government and the policy has been framed. So
That is not.
state will never refer it to the DCA.
That power is different. State government can definitely, there is.
Only the state government can reference.
Well, I'm grateful for this query. The Supreme Court has said that when there are two regulators in the market, the statutory regulator can examine the things and can say that we deal with the tender process and the allotment of shops. We don't deal with the competitive aspect of the matter. We are hereby referring this matter to the Competition Commission. This is what is provided in the scheme of the Act itself. They have the authority. And similarly, during the course of the examination of some things, if the Competition Commission comes to a finding that it is the jurisdiction of the state government, they can make a reference to the state government. So it's a vice versa provision. Let's just read out one of those two provisions.
So I think that's why we are saying that regular state. Because CCI made up.
They can't initiate the proceedings. If I am not in a position to satisfy this honorable court that Article 151 makes it a confidential document and they cannot have access to this, the entire case goes. The foundation goes. Well, I was just referring to section 20 and 21. I'm sorry, 21 and 22 for answering that query. Section 21 says reference by statutory authority and 21 says reference by commission. Section 21 is reference by statutory authority. Where in the course of a proceeding, before any statutory authority, an issue is raised by any party that any decision which such statutory authority has taken or proposal to take is or would be contrary to any of the provisions of this Act, then such statutory authority may make a reference in respect of such issue to the Commission, provided that any statutory authority may suo motu make a reference. Now, similar provision has been made in 21A. reference by commission, where in the course of a proceeding before the commission, an issue is raised by any party that any decision which the commission has taken during such proceeding or proposes to take is or would be contrary to any provision of an act whose implementation is entrusted to a statutory authority, then the commission may make a reference in respect of such issue to such authority, statutory authority. Now, in case they have from somewhere received an information, the Competition Commission, that there is a bid rigging, there is a cartel which is moving on, or on account of the policy of the excise policy of the state government, something is going wrong. They can make a reference. The CCI could have made a reference under section 21A to the state government, that we have prima facie formed our opinion that this policy is creating such kind of things. The state government would have examined and sent the matter back to the CCI. Thereafter, the CCI would have initiated proceedings. Now, all this is in a special law created for carving out a special jurisdiction for the Competition Commission. Neither it should overlap nor it should transgress the jurisdiction. There is a case that on account of transgressing its authority or jurisdiction, by utilizing the CAG report, it is abusing its position. Now, for that purpose, Manoj, this issue came up before the Honorable Supreme Court. This court, the judgment has not been uploaded. I think so. Can we immediately not upload this?
Yes, sir.
2013. 2013, volume 7. Yes. 2013, volume 7, SCC, page 1. Arun Kumar Abhuwa versus Vimna Khan. Before that, not into that, I'll just read out one of the parts of the report of the Director General, which we have placed on record as an extra P6, page 524. The read note from Annexure P6.
Yes.
Annexure P6 at page 525.
Yes.
524 is the report of the Director General. P6 begins from page 524, investigation report, Office of the Director General. Annexure. It begins from page number 531. Executive summary. The bulky record takes longer time in offering and coming on the screen.
Most of the part has been covered.
Yes, that is redacted. That is our further submission. That Director General has bifurcated his report in two parts, confidential and non-confidential. And he has shared only non-confidential part with us. But there's a regulation to this effect, which empowers the Director General to do this. The regulations are known as Competition Commission of India General Regulations. And the procedure has been prescribed in Regulation 17.
Under section 31, the compensation can examine the city safeguard has been a quantity to explain not following any.
Well, combination is a different case altogether.
Effect or
Section 31 combination is an entirely different thing. It is on account of the mergers and acquisitions. This doesn't apply because section 29 makes the foundation for 31. Section 29 says procedure for investigation of combinations. That's an independent issue altogether.
31 is the final order.
But it is final order.
They can approve it or disapprove it.
It is final order for section 29 matters. Section 29 says procedure for investigation of combinations. This is not our case. It says, I'll read 29, where the commission is of the prima facie opinion that the combination is likely to cause or has caused an appreciable adverse effect on competition within the relevant market in India, it shall issue a notice to show cause to parties to combination, calling upon them to respond within 15 days. Just to give example, Microsoft was bifurcated in two parts, and that was made a combination in the United States of America. They have two entities now. The allegation was that Microsoft is having exclusive autonomy and monopoly. It relates to such kind of things. 29, 30, and 31 combinations. Primarily, it is for merger and acquisitions. Only then such kind of entities come into existence. For that note, I'll just read out 28, section 28, which clarifies this. 19 and 26 will equally apply to combinations because that every aspect will apply to 28 onwards precedents, but they are only in relation to division of an enterprise. Can you see section 28? Tribunal can't exercise the power in view of Article 151. That is our first submission. In case they can't have access to the CAG report, they have no case. The CAG report itself is like. Not why not at this? This is how the Honorable Supreme Court has said that writ would lie against such. I'll just read out those 3-4 judgments. When they have no jurisdiction, this jurisdictional issue is to be addressed only before this honorable. Cartel will come later on. Cartel is the substance emanating from the CAG report. And in case they can't touch the CAG report, there's no question of what has been written or what objections or suggestions have been given in the CAG report. No authority can be permitted to exceed.
On the basis of CAG report, on the basis of complaint of private purpose.
It would have been a different case altogether. As I have stated earlier, I would have not argued this point. And CCI can't say that all right, don't go to that proposition. We can examine the cartel. We have found the cartel. From where? They have found the cartelization or the suggestion about that, which state government has yet not examined or found trustworthy. The CAG report cannot be found the basis of it. And entire prima facie opinion is based on CAG report. Director General report is based on CAG report. I will just read out that part. What the Director General has said. He said that this is the statutory authority emanating from MP Excise Act, and therefore it is not cartelization. This is what the Director General has said in so many words. The confidential, non-confidential version of the DG report is in Annexure P6, page 524. That is why they have asked him to again inquire, because they wanted to somehow exercise the power. DG found that it is not that case.
They will not find any material.
Normally it doesn't happen. It doesn't happen. My lord, I have no material and no occasion. Well, my humble submission is that there is no necessity for us. Well, thereafter, the further appeals will be available. So far as the jurisdiction is concerned, I'll try to satisfy this honorable court that when jurisdictional issue is raised, that they have no jurisdiction, and the foundational belief of exercise of suo motu power is defective, constitutional. Nothing further should move. This is what I will be making my case about. Lord, may kindly see Annexure P6, which is the report of the non-confidential version of the report of the Director General. beginning from page 525, 524. It is in different chapters and paragraphs. Page 531 begins the executive summary. I don't have it. Page 531, executive summary. The instant case was taken as suo motu case by the Competition Commission of India under Section 19 of the Act, alleging cartelization and supply of country liquor by distillers to retailers in various districts of Madhya Pradesh during the period from 2012 to 17, as observed in CAG report, so and so. Based upon this, he has proceeded further. Let me kindly come to page 536, which is the case background.
536.
536. Chapter 1, Introduction, Case Background.
Yes.
The instant case was taken up suo motu by the Competition Commission on the basis of the Comptroller and Auditor General of India report number so and so on revenue sectors of Government of Madhya Pradesh for the financial year so and so. Then, my lord, the details have been given. Lord, may kindly come to page number 544, Chapter 2, Investigation Procedure and Timeline. 2.1, page 544. 544. 544, caption is Chapter 2, Investigation Procedure and Timeline. Clause 2.1.
Yes.
Based on the plain reading of the prima facie order issued under Section 26(1) of the Act, it can be undeniably inferred that the investigation required unearthing and collecting evidences which exhibit cartelization among distillers in their collusive conduct of bid rigging with respect to tenders floated for supply of country liquor in the districts of Madhya Pradesh during the period so and so. In order to examine the allegations pertaining to cartelization among distillers, a search and seizure operation was planned by the investigation after gathering sufficient information on the relevant market and the industry in general. Then it was done. 2.3 says records were received and summoned. Then details have been given. Lord, may kindly come to page 550, Chapter 4, Investigation and Findings.
Yes.
4.1 says, before probing the collusive conduct of the opposite parties, it would be prudent to note the details of the product under consideration, that is country liquor, in two variants, plain and masala, and packed in glass and PET bottles, and the details of the tender process followed for such supply and distribution by the government of the state of Madhya Pradesh. Then issues have been framed. First issue is, what are the major characteristics of country liquor business in the state of Madhya Pradesh? And we'll now come to page 558, Administrative and Regulatory Control. I'm sorry, before that, now page 557. Clause 4.2.13. Page 557.
Yes.
4.2.13. One of the significant reasons behind variation in share of country liquor in the volume of alcoholic beverage market. Got it? One of the significant reasons behind variation in share of country liquor in the volume of alcoholic beverage market of different states lies in the contradistinction in terms of their policies and implementation. The states, through their excise policies, control the entire supply chain of alcoholic beverages from manufacturing and distribution to registration and retail. Then 4.2.15. It is pertinent to note that Commission in its order had mentioned that distilleries produce rectified spirit from which country liquor bottling units manufacture a country liquor. Both distilleries and country liquor bottling units are governed under the MP Excise Act, the MP Distillery Rules, and MP Country Spirit Rules, framed under the said Act, govern distilleries and country liquor bottling units separately. 4.2.16. A plain reading of the aforesaid Act and rules unarguably promotes state government controls through Office of Excise Commissioner on manufacturing, storage, distribution, and sale of country liquor in the state of Madhya Pradesh. Then comes on our next chapter, Administrative and Regulatory Control over country liquor business in Madhya Pradesh. We'll be referring to paragraph number 4.4.6 at page 561. 561, last paragraph, 4.4.6. The Excise Commissioner of Madhya Pradesh was asked to furnish its comments on these observations by notice dated 21 in its submission dated so and so. The Excise Commissioner pointed out that the decisions regarding the policy of country liquor are a prerogative of the state governments according to clause 51 under Article 246, 7 schedule of the Constitution. The distillers of the state were only allowed to participate in the tender process of country liquor after from 11/12 with a view to promote industries in the state. The Excise Commissioner further informed that in the excise policy for the year 11/12, it was directed that from 1/4/2011, filling of country liquor in sealed bottles would be done in bottling units or distillery premises only, not at the warehouses. Let's skip this 4.4.8. The investigation also confronted these facts to Mukesh Neelu, Additional Excise Commissioner of Madhya Pradesh, who was designated as a coordinator for the instant investigation to better comprehend the changes made in the tendering process for supply of country liquor in the state over the years. On being asked to explain the rationale behind the direction to allow bottling only in bottling units, distillery premises instead of warehouses, while recording his statement on 12/7/2022, Sri Neema stated that the above measures were taken in view of the complaints received by the state government regarding quality and packaging of country liquor. Then we come to 4.4.10.
Yes.
Paragraph 4.4.10, page 564. 564, paragraph 4.4.10.
CID was not satisfied with.
That's why they ordered for further inquiry under subsection 3. Because he stated that this is an obvious regulator available in the state itself.
In law 34 matter, I had occasion to call the details of how many bottles were in the one bag and how many bottles were sent to the warehouse. There was absolutely no detail. Quantity of manufacturing, bag की कितनी bottle होती है, कोई numbering नहीं कुछ नहीं. This is how it started. Writing में आया एक्साइज डिपार्टमेंट से there is no detail. एक बैच में कितनी बॉटल हम मैन्युफैक्चर करते हैं उसको लाते हो गया वेयर हाउस में कोई रिकॉर्ड नहीं
Very unfortunate.
पूरा पूरा एक ट्रक पकड़ा गया पर कोई एक ही बैच नहीं पकड़ा दिस इज हाउ दिस cartelization.
It doesn't affect the cartel. That is their revenue. That is the system. That is the system of evading payment of taxes and duty.
So nobody objects to us and this happens. कोई जितनी बना रहा है तो एक ही नंबर को छोटे ट्रक करना है.
Can the CCI cure this? The CCI can rectify this. Can this propose? Can CCI?
Ultimately, the consumer will suffer.
But CCI doesn't have the power to ask the state government to correct, modify or amend the law. They cannot say that you frame a different policy. That is interference as per the provisions of the Constitution. CCI is not that authority. And in case they can't remedy this, the CCI Act doesn't apply. That will be my last submission. The only thing which they are doing by way of penalty is that you correct this, and since you have done this, 10% penalty or 3 times of the penalty. Can they impose penalty of the state government? Can they say that now hereafter, I will dictate you what will be your policy? And this honorable court would definitely say, nobody can dictate the state government for the formation of a policy. That is their prerogative. So in case the policy is defective, it is for the state government to improve that. And I will not read 2 judgments, Bharti Airtel and Rajasthan Cylinder, which says that this is a perfect system. There is no cartelization. This is oligopoly system, which is prevailing in such kind of markets. State may not partakes with this exclusive privilege of dealing with intoxicating liquor. Nobody else has that power. And while doing that, they appoint persons to manufacture liquor, sell liquor, they issue licenses, variety of license. Nothing is left from the regulation. Even everything in all states, in the entire country, is regulated by the state excise department. This is the only thing which is prevailing in the country. Either the parliament,
On paper, it looks good.
within this premises, my lord, we can only say argue on the basis of the papers only. Papers and documents. And in case, my lord, the state government wants to take any action, they have got biting teeth. They can catch hold of the violators. Officer in charge, a higher rank officer in the rank of assistant excise officer, sits in my distillery every day. It is his duty to see that I manufacture as per the specifications given for preparation of the two qualities of masala and plain liquor. He gives me the stickers. The stickers are placed on the bottles. He maintains the entire record. Under his signature, the stock is released from the transit passes are issued by them. Warehouse also issues indents, and thereafter it is sent for sale. So far as regulation is concerned, it's perfectly a regulated commodity. Now, what?
One matter, not for selling anything. It stands to be like, easily you can rub and remove that. Even that case also came before.
Long back, some advocate arguing the matter, I say that in our country.
The government is unable to understand or fail to understand what is going on, and
At best,
not examining how they are doing.
looking to the prosecutions which are being every day conducted, it seems that the agencies are working functionally properly. But in case it is done in such a manner that it escaped their attention or somebody connive with them, that would be a solitary instance of very, say, distinctive instances. It cannot be generalized in manual submission. I was reading from page 564, paragraph.
Examine, let them examine whether it is perfect or not, or some.
The question is whether they can do it in the teeth of Article 151 or not. Had it been a complaint, simply written.
There is no cartilage in that.
Can they read the contents of the CAG report? That is the question. And for that purpose, I will straight to come to the Supreme Court judgment. It has been uploaded as item number. 2013, volume 7, SCC, page 1.
Main case.
First item. Not in 10304.
Hmm?
10304.
I'm arguing in 15.2. 10304. They do it first.
Arun Kumar Agrawal.
Arun Kumar Agrawal was a union of India. This was a case where the ONGC was involved. The discussion part was taken from paragraph number 32. Before that, paragraph 31, can you see? I'm reading from paragraph 31. The learned senior counsel submitted that assigning of a PI is a well-defined concept and referring to the judgment of this court in water form. Learned senior counsel submitted that the transfer of a share does not result in transfer of underlying assets. Let's skip this. Next sentence, The learned senior counsel submitted that various decisions taken in this case, either from the side of Union of India, ONGC, or by respondent 3 and 4, were commercial decisions based on which the parties have acted, and this court, sitting in its jurisdiction, shall not interfere with such commercial decisions. Referring to the report of CAG, then its senior counsel submitted that this court shall not place any reliance on the report of the CAG and grant any relief to the petitioner based on the CAG report, since in case of any dispute between the ministry and CAG, that is to be resolved by Parliament and not this court, sitting in this jurisdiction under Article 32 of the Constitution of India. This was the objection. Para 32. The question that falls for consideration in this case is whether this court sitting in this jurisdiction is justified in interfering with a complex economic decision taken by a state or its instrumentalities in the absence of violation of any statutory provision or proof of malafide or on extraneous and irrelevant considerations. The government had initially the exclusive privilege of exploration of mineral and ore resources. Let's skip this paragraph. Come to paragraph number 54. The tag report. Paragraph 54. The petitioner has placed considerable reliance on the Comptroller and Auditor General report. Some of the comments in the CAG report were highlighted by the counsel appearing for the petitioner to contend that the declaration of fresh discoveries during the appraisal development phases within delineated discovery development areas amounted to irregular extension of exploration activities, which is not in consonance with the terms of the PSC. The petitioner has also sought a direction to CAG, Government of India, to calculate the alleged losses from payment of 100% royalty and cess by ONCG before the Karen Vedanta deal and for direction to so and so. Paragraph 56. CAG may be right in pointing out that public monies are to be applied for the purposes prescribed by Parliament and that extravagance and waste are minimized, and that sound financial practices are encouraged in estimating and contracting and in administration generally. We have come across several instances where considerable reliance has been placed on the CAG report and projecting it as gospel truth. Let us examine the role of the CAG under our constitutional scheme. An article has been quoted. We come to para 60. The audit of the union and the state is under section 13 of the Act. The scope of the audit extends to the audit of all expenditure so as to ascertain whether the monies shown in the accounts as having been disbursed were legally available for such disbursement and whether the expenditure conforms to the authority which governs it. The CAG has to satisfy himself that the rules and procedures designed to secure an effective check on the assessment, collection and proper allocation of revenue are being duly observed under section 16. The CAG also has to examine decisions which have financial implications, including the propriety of the decision making. The reports of the CAG are required to be submitted to the President, who shall cause them to be laid before each House of Parliament as provided under Article 151(1). In relation to the states, reports are submitted to the Governor, who shall cause them to be laid before the legislature of the state as per Article 151(2) of the Constitution. When reports are received in Parliament, they are scrutinized by the Public Accounts Committee. The PSC is established in accordance with Rule 308 of the Rules of Procedure and Conduct of Business in Lok Sabha. The functions of the PSC is to examine the accounts of the union and the report of the CAG. The PSC shall be principally concerned whether the policy is carried out efficiently, effectively, and economically, rather than with the merits of the government policy. Its main functions are to see, one, that public monies are applied for the purposes prescribed by Parliament, that extravagance and waste are minimized, and that sound financial practices are encouraged in estimating and contracting and in administration generally. The PSC also has the power to receive evidence, the power to send for persons, papers, and record, and can receive oral evidence on solemn affirmation. Once the report is prepared, the report of the PSC is presented to the House. Then P.D. Basu's commentary has been quoted. I'll come to para 65. Beginning from the action report. Para 65 says, action taken reports are then required to be made out by the ministries. The Speaker has the power to issue directions under the rule and procedure. Direction 102 requires the government to, as early as possible, furnish the PSC with a statement showing the action taken on the recommendation of the PSC report. Parliament has before it not only the report of the CAG, the report of the PSC in the first instance drawn up after hearing, the view of the ministries, the action taken report, including the reply of the government, and the further comments of the PSC on the reply of the government. We have referred to the report of the CAG, the role of the PSC, and the procedure followed in the House, only to indicate that the CAG report is always subject to scrutiny by Parliament, and the government can always offer its views on the report of the CAG. The question that is germane for consideration in this case is whether this court can grant relief by merely placing reliance on the CAG report. The CAG report is always subject to parliamentary debates, and it is possible that PSC can accept the ministry's objection to the CAG report or reject the report of the CAG. The CAG indisputably is an independent constitutional functionary. However, it is for Parliament to decide whether after receiving the report, that is PSC to make its comments on the CAG report. We may, however, point out that since the report is from a constitutional functionary, it commands respect and cannot be brushed aside as such. But it is equally important to examine the comments what respective ministries have to offer on the CAG report. The ministry can always point out if there is any mistake in the CAG report or the CAG has inappropriately appreciated the various issues. For instance, we cannot as such accept the CAG report in the instant case. There are 70 conclusions like this. In such circumstances, we find no merits and so on. So from this perspective, the CAG report has to move to several internal doors, get the facts examined by committees and ministries. They record their notes and objections and suggestions. Thereafter, again, it is sent back. Then governor examines it. Thereafter, it is placed or not placed before the state legislature. If at all, the state legislature or the parliament says that we accept this, only then and thereafter, it comes into the public domain. Just two small paragraph of the DG's report, where he has
Reference made to it by central government or the state government. This is under Article 151 of the Constitution,
which reference from?
under Section 19(1)(b).
No, that is by the statute.
Reference by the state government or central government.
That is by the statute. In this judgment.
Under Article 1.
In this judgment. In this judgment.
No, this act.
This is not the statutory authority has been defined independently.
So it says the inquiry into a certain agreement or dominant position of the enterprise, Section 19 on the commission may inquire into any contravention of so and so, on receipt of any information and reference made to it by central or state government.
Yes, that's what I'm saying. If after examining the CAG report, the state government would have come to a conclusion that we satisfy.
Under Article 1, this reference should be under 1.
No. It will be referenced under Section 19. Because that would be an administrative exercise, not a legislative exercise. The legislature of the state would opine that we agree.
If there is reference made by the government should be after examining the AG report under.
Yes.
Article 1.
So that is the first constitutional stage which the CAG report has to pass. The legislature has to say that, yes, we concur with the finding of the CAG. And therefore, we find that since this matter falls into the definition of competition or violation of Competition Act, therefore, we are making a reference under Section 9. Then this CAG report becomes available to CCI. When a reference is made based upon CAG report by the state government, not otherwise.
CCI has no power to call directly the.
Yes. Yes, this is not submission. Anybody could have gone there. That I think that they are making a cartel. Some people do it. Recently, a boy studying in Bangalore has filed a case against Ola and Uber by saying that if you see like this, it is anti-competitive. The CCI entertained that, rejected that. Against that, he preferred an appeal to the Supreme Court. Supreme Court said that you fall into the category of any person, but don't make abuse of the process of law like this. So any person can do it. In our case also, whosoever goes to the liquor shop could have filed this objection that I am the consumer and please entertain my complaint, and CCI would have entertained the complaint. But here is a case where the CAG report exclusively is the foundation made by the CCI for the purpose of making prima facie opinion, on the basis of which they have directed the DG to conduct the point. The other point is based upon we have not finished this in paragraphs of DG report. where he has concluded that this is on account of the policy of the state government. So that I may complete that BG part. Page number 563 of annexure P6. Page number 568.
report accordingly is in your favor. And
Not in my favor. He has not, kindly may not give me one moment to read only one paragraph, 4.4.25 at page 569. In view of the above, P6, page 569, 4.4.25. In view of the above, it is quite clear that the excise policy of Madhya Pradesh played a vital role in creating the business and regulatory environment for country liquor business in the state. In fact, the policy linked conditions and restrictions resulted in limiting the competition by reducing the number of eligible participants. The case of the CCI projected in the prima facie opinion is that you are not allowing those distilleries which are adjoining states in UP, Rajasthan, Bihar. You are restricting your business only amongst 11 distilleries only. From that perspective, the Director General has observed this. In view of the above, it is quite clear that the excise policy of Madhya Pradesh played a vital role in creating the business and regulatory environment for country-built business in state. In fact, the policy-linked conditions and restrictions resulted in limiting the competition by reducing the number of eligible participants. The answer could be and is the state doesn't want outside players. They have to regulate everything. They have to appoint officer in charge in each district. Now, in case they appoint an officer in charge in Bihar by permitting persons having distillery in Bihar, they'll have no control over this. So this is for the state government to decide in which area they have to travel and do their business. But I'll be citing only two judgments. The first judgment is 2019 volume 2 SCC, Bharti Airtel case. This serial number. 2019 volume 2 SCC, page 521. 2019 volume 2 SCC 521. Competition Commission versus Bharti Airtel. This judgment has been uploaded at serial number 3 on the reference
Item 15.2.
Lord, here was a case where when CCI exercised their power against the regulators, against these persons, it says that we already have a regulator known as TRAI, Telecom Regulatory Appellate Authority, and therefore you can't interfere in this. Now, I'll straight come to paragraph, page number 47, paragraph 97.
but for FI, we don't have president.
They have lot like SEBI. SEBI is an independent regulator.
No, but in the excise matter, we have only act and regulate.
Yes.
To control all.
The excise department is the regulator. The state is the regulator.
CCI reserve TRAI.
Here the state has been treated as a regulator by the CCI. That on account of your regulations, the business is being carried out in the state. The state of Madhya Pradesh is treated as a statutory regulator by the CCI. Page 47, my lord, paragraph number 97. Page number 47, my lord. I'm sorry. Page number, paragraph number 79, my kindly be seen.
Para 97.
Para 79, my lord. Jurisdiction of CCI. Jurisdiction of CCI. This is the principal issue, which is the bone of contention. In order to discuss and analyze this aspect, it would be apt to take note of the salient provisions of the Competition Act and so on and so forth. I'll skip this one and straight back come to para 97. Where the court has said how TRA is a regulator. Para 97, from the aforesaid. From the aforesaid analysis of the scheme contained in the TRA Act, it becomes clear that the functioning of the telecom companies, which are granted license under Section 4 of the Telegraph Act, is regulated by the provisions contained in the TRA Act. TRAI is a regulator which regulates the telecom industry, which is the statutory body created under the TRA Act, and then regulations have been framed. Let me kindly come to paragraph number 103. In this paragraph, the Supreme Court says that the first instance dispute should be discussed, analyzed, and resolved at the TRAI. And thereafter, the matter should have been sent to the CCA. I'll read para 103. We are of the opinion that as TRAI is constituted as an expert regulator body, which specifically governs the telecom sector, the aforesaid aspects of the disputes are to be decided by TRAI in the first instance. These are jurisdictional aspects. Unless TRAI finds fault with the IDOs on the aforesaid aspects, the matter cannot be taken further, even if we proceed on the assumption that CCI has the jurisdiction to deal with the complaints, information filed before it. Para 104, where the Supreme Court has said that CCI will be ill-equipped. Para 104. We therefore are of the opinion that the High Court is right in concluding that till the jurisdictional issues are straightened and answered by TRAI, which would bring on record findings on the aforesaid aspects, CCI is ill-equipped to proceed in the matter. Having regard to the aforesaid nature of jurisdiction conferred upon an expert regulator pertaining to the specific sector, the High Court is right in concluding that the concepts of subscriber, test period, reasonable demand, test phase and commercial phase rights and obligations, reciprocal obligations of service providers, or breaches of any contract and or practice arising out of the TRAI Act and the policy so declared are the matters within the jurisdiction of the authority that set under the TRAI Act only. Only when the jurisdictional facts in the present matters as mentioned in this judgment, particularly in para 72 and 102 above, are determined by TRAI against the IDOs, the next question would arise as to whether it was a result of any concerted agreement between the IDOs and supported the IDOs in that endeavor. It would be at that stage CCI can go into the question as to whether violation of the provisions of the TRAI Act amounts to abuse of dominance or anti-competitive agreements. That also follows from the reading of Section 21 and 21A of the Companies Act. Next para. The issue can be examined from another angle as well. If CCI is allowed to intervene at this juncture, it will have to necessarily undertake an exercise of returning the findings on the aforesaid issues, aspects, which are mentioned in para 102 above. Not only TRAI is better equipped as a sectoral regulator to deal with these jurisdictional aspects, there may be a possibility that the two authorities, namely TRAI on the one hand and CCI on the other hand, arrive at conflicting views. Such a situation needs to be avoided. This analysis also leads to the same conclusion, namely, in the first instance, it is TRAI which should decide these jurisdictional issues which come within the domain of the TRAI Act, as they not only arise out of the telecom license granted to the service providers. The service providers are governed by the TRAI Act and are supposed to follow various regulations and directions issued by TRAI itself. This takes us to the next level of the issue, namely, whether TRAI has the exclusive jurisdiction to deal with matters involving anti-competitive practices to the exclusion of CCI altogether because of the reason that the matter pertains to telecom sector. Then these issues have been answered. You know, skip this. No?
112.
Yes, 112. Obviously, all the aforesaid functions not only come within the domain of CCI. TRAI is not at all equipped to deal with the same. Even if TRAI also returns a finding that a particular activity was anti-competitive, its powers would be limited to the action that can be taken under the TRAI Act alone. It is only CCI which is empowered to deal with the same anti-competitive act from the lens of the Competition Act. If such activities offend the provisions of the Competition Act as well, the consequences under that act would also follow. Therefore, contention of the IDOs that the jurisdiction of CCI stands totally ousted cannot be accepted. Insofar as the nuance exercised from the standpoint of the Competition Act is concerned, CCI is the experienced body.
Part is only within the domain of CCI.
Yes,
That they are examined.
they can't because the CAG report cannot be touched.
Again, you are coming to that part.
Number of, judgments will definitely take care of both aspects. We cannot say, read in isolation reason. I'll just read out next paragraph 113. I'm sorry, last paragraph of this 112. Further, CCI is more likely to opt for structural remedies, which would lead the sector to evolve a point where sufficient new entries induce, thereby promoting genuine competition. This is specific and important role assigned to CCI cannot be completely whisked away, and the committee between the sectoral regulator, that is TRAI, and the market regulator, CCI, is to be maintained. The conclusion of the aforesaid discussion is to give primacy to the respective objections of the two regulators under the two Act. At the same time, since the matter pertains to the telecom sector, which is specifically regulated by TRAI Act, balance is maintained by permitting TRAI in the first instance to deal with and decide the jurisdictional aspect, which can be more competently handled by it. Once that exercise is done, and there are findings written by TRAI which lead to the prima facie conclusion that the IDOs have indulged in anti-competitive practices, CCI can be activated to investigate the matter going by the criteria laid down in the relevant provisions of the Competition Act and take it to its logical conclusion. So these stages have been visualized. When there are two equal strength regulators, the first regulator, which is providing all systems of licensing, manufacture of alcohol, supply and sale, it has to be first of all examined by that regulator, which is the state government. And thereafter, after receiving the findings, CCI can do this. Now, look, para 115 mein kindly be seen. Whether the writ petitions filed before the High Court of Bombay were maintainable. Para 115. Here comes the scope of judicial interference under Article 226. As per the RJIL as well as CCI, the High Court could not have entertained the writ petition against an order passed under Section 26(1) of the Competition Act, which was a pure administrative order and was only a prima facie view expressed therein and did not result in serious adverse consequences. It was submitted that the findings of the High Court that such an order was quasi-judicial order is not only erroneous, but it is contrary to the law laid down in same case. The respondents, on the other hand, have submitted that the judgment in the above case had no application in the instant case, as it did not deal with the sector that is regulated by statutory authority. Moreover, such an order was quasi-judicial in nature and cannot be treated as an administrative order, since it was passed by CCI after collecting the detailed information from the parties in the holding the conferences, calling material details, documents, affidavits, and by recording the opinion. Then was submitted like this. Para 118, my lord, conclude this aspect. It was, however, argued, I'm reading of 118. It was, however, argued that since SAIL was not dealing with the telecom sector, which is regulated by the statutory regulator, namely TRAI, under the TRAI Act, that judgment would not be applicable. Merely because the present case deals with the telecom sector would not change the nature of the order that is passed by CCI under Section 26(1) of the Competition Act. However, it raises another dimension. Even if the order is administrative in nature, the question raised before the High Court in the writ petitions filed by the respondents touched upon the very jurisdiction of CCI. As is evident, the case set up by the respondents was that CCI did not have the jurisdiction to entertain any such request or information which was furnished by RJIA and two others. The question thus pertained to the jurisdiction of the CCI to deal with such matter, and in the process, the High Court was called upon to decide as to whether the jurisdiction of CCI is entirely excluded or to what extent CCI can exercise its jurisdiction in these cases where the matter could be dealt with by another regulator, namely so and so. Then para 121 is the conclusion. I'm sorry, last para of this 118. When such jurisdictional issues arise, the writ petition would clearly be maintainable as held in barium chemical case. So when we are, yes, But before that, no, that last line I forgot to read from para 118. When such jurisdictional issues arise, the writ petition would clearly be maintainable. Now 121. The only exception which has been carved out in 121 is this. That CCI acted prematurely. Whether the High Court could give this finding on merits, 121. It was difficult to catch up with the speed with which my lord reads the things. Otherwise, also everybody knows, particularly we people from North know very well how fast and quick my lord is at the computer. Para 121 says, once we hold that the order under section 26(1) of the Constitution of the Companies Act is administrative in nature, Competition Act, and further that it was merely a prima facie opinion directing the Director General to carry the investigation, the High Court would not be competent to adjudicate the validity of such an order on merits. The observation of the High Court giving findings on merits, therefore, may not be appropriate. That is the only distinction. No. High Court with para 118 says. Para 118 says that if there is the jurisdictional issue, that alone can be exercised, that alone can be analyzed in the jurisdiction. And I have given two illustrations to demonstrate that they have no jurisdiction to initiate the process. On merits, otherwise also, merits have yet to come up on surface on the record. 122. At the same time, since we are upholding the order of the High Court on the aspect that CCI could exercise jurisdiction only after proceedings under the TRAI Act had concluded, attained finality, that is, only after TRAI returns its findings on the jurisdictional aspect, which are mentioned above by us, the ultimate direction given by the High Court, quashing the order passed by the CCI, is not liable to be interfered with, as such an exercise carried out by CCI was premature. The result of the discussion would be do that. So this judgment definitely takes care of both the aspects of the matter. This petition is maintainable so far as jurisdiction is concerned. We are concentrating only on this issue, the jurisdictional aspect and the exercise of power on suo motu basis. Now, consider the second judgment, Rajasthan Cylinders. Citation is 2020, volume 16, number 2. 2020, volume number 16, SCC, page 615. Rajasthan Cylinders was a unit of. Here, my lord, the Honorable Supreme Court has categorically analyzed as to what were the circumstances in which one can even infer what is bid rigging, cartelization. I'll come to para 92 straight away. Sorry, para 88. 88. Here the Supreme Court has discussed what are the factors which lead to cartelization. Para 88, Mary. Yes. The factors which have influenced the authorities below in coming to the conclusion that the appellants had colluded and formed a cartel which led to bid rigging have already been noted above. To recapitulate, the authorities below have been influenced by the following factors. I'll skip this. After deliberating on the opposite aspects, CCI has concluded that there is an active trade association in which many of the appellants are members. That product in question, namely gas cylinder, is of a particular specification, which is needed by IOCL in large numbers every year. And there are very few manufacturers and suppliers of this product to IOCL and two other buyers. Come to para 89. We may say at the outset that if these factors are taken into consideration by themselves, they may lead to the inference that there was bid rigging. Then it was discussed. Para 90. However, this is only one side of the coin. The opposite factors are to be analyzed keeping in mind the ground realities that were prevailing, which are pointed out by the appellants. These attendant circumstances are argued in detail by the counsel for the appellants, which have already been taken note of. We may recapitulate the same in brief here enough. Can you see Roman clause 3 and Roman clause 4 for this one, Roman clause 6 also. Then I'll come to paragraph number 91, where the manner of tender process has been discussed. The manner in which, para 91, the manner in which tendering process takes place would show that in such a competitive scenario, the bid which the different bidders would be submitting becomes obvious. It has come on record that just a few days before the tender in question, another tender was floated by BPCL, and on opening of the said tender, rates came to be known. In a scenario like this, that obviously becomes a guiding factor for the bidders to submit the bids. 92. When we keep in mind the aforesaid fact situation on the ground, those very factors on the basis of which CCI has come to the conclusion that there was cartelization, in fact, becomes valid explanation to the indicators pointed out by CCI. Can you see from middle of this paragraph, therefore, on the right side, therefore, it became necessary to sustain themselves in the market. Hence, the factor that these suppliers are from different regions, have different cost of manufacture, would lose its significance. In last paragraph, last 3 lines, the main purpose for such a manufacturing would be to remain in fray and not to lose out. Therefore, it would be ready to accept lesser margin. This would answer why there were never near identical bids despite varying cost. Why they have submitted identical bids can be inferred from this paragraph. Now, there is an allegation that you always hold a meeting before submitting the tenders. The tenders are submitted at Gwalior. They all stay in one hotel and they hold a meeting. For that purpose, para 93 has been clarified by the Honorable Supreme Court. Insofar as meeting of bidders in Mumbai just before the date of submission of tender is concerned, some aspects pointed out by the appellants are not considered by CCI or compact at all. No doubt the meeting took place a couple of days before the date of tender. No doubt the absence of agenda coming on record would not make much difference. However, only 19 appellants had attended that meeting. Many others were not even members or did not attend the meeting. In spite thereof, even they quoted almost same rates as the one who attended the meeting. This would lead us to the inference that reasons for quoting similar price was not the meeting, but something else. The question is, what would be the other reason and whether the appellants have been able to satisfactorily explain that and rebut the presumption against them. The explanation is market condition. The explanation is market condition leading to the situation of oligopsony that prevailed because of limited buyers and influence of buyers in the fixation of prices was all prevalent. This seems to be convincing in the given set of facts. The situation of oligopsony can be both ways. There may be a situation where the sellers are few and they may control the market and by their concerted action indulge into cartelization. It may also be, as in the present case, a situation where buyers are few and that results in the situation of oligopsony with the control of buyers. Then the judgment of Supreme Court in the case of Excel Crop Care has been quoted. Its collusive tendering process has been discussed. We come to para 97, where the opposite of oligopsony has been discussed. Monopsony consists of a market with a single buyer. Got it? Para 97. Monopsony consists of a market with a single buyer. When there are only few buyers, the market is described as oligopsony. What is emphasized is that in such a situation, a manufacturer with no buyers will have to exit from the trade. Therefore, first condition of oligopsony stands fulfilled. The other condition for the existence of oligopsony is whether the buyers have some influence over the price of the inputs. It is also to be seen as to whether the seller has any ability to raise prices or it's to reduce eliminated by the aforesaid buyers. Pausing here for a moment, let the entire process begin when based upon the retailer's business, the state government excise department fixes the base rate. This base rate is fixed, and when the tenders are required to be filed, the maximum retail price, the maximum selling price is also fixed by the state government. Now, there is a very small difference of 5 to 10 rupees in between the maximum selling price and the base rate.
The matter of this manpower supply. There is no competition because minimum service charge is 5%, maximum 10. Everybody is quoting 5%. Rest of and reduce.
Right.
So there is no competition in that.
So it will be a different, that is called oligopsony. So this minor difference or identical rates of everybody cannot be treated to be a cartel. Now, another aspect of the matter, when the base rates and the MSP and MRP are fixed and we have to set our rates within this periphery. Everybody says 1.2 or 1.5 or 1.3. This is the difference. Now, my lord, the best part is that when all these tenders are presented before the authorities and they select lowest one, L1, they ask everybody to come to that level. In case he is the lowest and we are the highest, we have to come to the rates of L1. Now, second stage of scrutiny is that all these recommendations are sent to the state cabinet, not the excise minister alone. The state cabinet examines everything and says that we don't agree with this, the entire tender process is hereby quashed. Or you ask the L1 to raise the rates and make everybody to raise their bids. So there are two more statutory filters in this very process. So it cannot be inferred that even we make a cartel, we can win the bids. The third aspect, I have been declared as L1 for Jabalpur district. I don't have a setup here. I don't have workshop, study anything. I don't want to take up this matter. And I say that I don't want to work in this area. They will say, all right, we'll give to other person. On the very same rates, it is given to other person. Where is the tendering process? Where is the cartel? Now, in case, my lords, I have that capacity, like there is fourth filter. The qualification is that every distiller has to supply liquor in the quantity of 2 crore proof litres or 80% of its manufacturing capacity. Associated Alcohols has a manufacturing capacity of 10 lakh crore of potable alcohol. But the ceiling limit is that we can sell and supply only 2 crore liquor only. Had it been 80% in a different manner, 2 crore or 80%, whichever is higher, I think I would have been the only person who would have been supplying liquor to the entire state. But this fourth filter further reduces the chances of competition. I have the capacity, but I can't sell it. So from all these perspectives, when one sees that there is a difference of only 5 rupees, 10 rupees, 15 rupees in between the base price, base rate, and the minimum or maximum selling price, nobody can think of it. Because what is cartel? It is defined well further. I'll just read out that. Cartel is that when we form association or we have a premeditated mind to cause harm to the state government, to benefit our own assets or to the consumer. Here is a case where I can't sell the liquor at a rate which I want. The rate is already fixed by the state. I am the person who is making it, manufacturing it. I am the sole distributor. That rate is fixed. When the product goes in the hands of the retailer, he has also the fixed amount of liquor. Not only this, the quality also cannot be improved. This is not a case where I can make better quality of country liquor. The specifications are given and everybody has to manufacture as per the specification. This much of extra neutral alcohol, this much of water, this much of flavoring agent and colors. Everybody has to do this. The labels are only of the state government. I can't paste my label on country liquor. It is only on the IMFL, which the labels are fixed. So what are the requirements of cartel? Cannot be seen from the entire exercise of tendering process. I can't form the cartel. So in case we make a meeting and say that all right, we will be participating, it doesn't reflect in the tenders. It doesn't reflect in the rates. I'm reading para 19 thereafter and 98. On a holistic view of the matter, we find that the appellants have been able to discharge the owners by referring to various indicators who go on to show that parallel behavior was not the result of any concerted practice. In Dystaf, the European court held that parallel behavior does not by itself amount to a concerted practice, though it may provide a strong evidence of such a practice. Nevertheless, it is a strong evidence of such a practice. However, before such an inference is drawn, it has to be seen that this parallel behavior has led to conditions of competition which do not correspond to the normal conditions of the market, having regard to the nature of the product, size, and volume of the undertaking of the said market. Thus, we examine the matter from the standpoint of market economy, where question of oligopsony assumes relevance. Whenever there is a situation of oligopsony, parallel pricing simplicity would not lead to the conclusion that there was a concerted practice, there has to be other credible and corroborative evidence to show that in an oligopoly, a reduction in price would swiftly attract the customers of the other two or three rivals, the effect upon whom would be so devastating that they would have to react by matching the cut. Richard Wish and David Bailey, Oxford Competition Law, discuss the theory of oligopolistic interdependence. These three paragraphs may kindly be seen. They're very interestingly and theoretically say this is the theory of oligopolic interdependence. In an oligopoly, a reduction in price would swiftly attract the customers of the other two or three rivals, the effect upon whom would be so devastating that they would have to react by matching the cut. Similarly, an oligopolis would not increase its price unilaterally because it would be deserted by its customers if it did so. Thus, the theory runs that in oligopolistic market, rivals are interdependent, they are acutely aware of each other's presence and are bound to match one another's marketing strategy. The result is that price competition between them will be minimal or non-existent. Oligopoly produces non-competitive stability. Oligopolistic recognize their interdependence as well as their own self-interest. By matching each other's conduct, they will be able to achieve and charge a profit-maximizing price, which will be set up at a supra-competitive level without actually communicating with one another. There does not need to be any communication. The structure of the market is such that through interdependence and mutual self-awareness, prices will rise towards a monopolistic level. The logical conclusion of the case against oligopoly is that since it is the market structure itself which produces the problem, structural measures should be taken to remedy it by deconcentrating the market. Unless this is done, there will be an area of consciously parallel action in pricing strategy, which is beyond the reach of laws against cartels and yet which has serious implications for consumer welfare. So this is the theory, Manoj, of oligopolic interdependence. Now, it is concluded like this.
By any of the high court. This is the NPT that we are telling or mobile application. No for discussions.
Not of the CCI members. Para 104 and 106 may kindly be seen. After taking up para 104, after taking note of the test that needs to be applied in such cases, which was laid down in DISTA and accepted in Excel Court, we come to the conclusion that the inference drawn by CCI on the basis of evidence collected by it are duly rebutted by the appellants, and the appellants have been able to discharge the onus that shifted upon them on the basis of factors pointed out by CCI. However, at that stage, CCI failed to carry the matter further by having required and necessary inquiry that was needed in the instant case. And then conclusion is, we thus arrive at a conclusion that there is no sufficient evidence to hold that there was any agreement between the appellants for bid rigging. Accordingly, we allow these appeals and set aside the order. So my effort of reading this judgment from paragraph 92 to 106 was that in this oligopoly market, which has been described in these paragraphs, it is imperative for the state government to have framed such, because there are only 11 participants. Only 11 participants will remain in all the excise years. Every year, only these persons will participate. It is for the state government to come up with a new policy if they want such kind of policy to be ignored or improved. We have a limited scope of housing our bids. The last judgment is, I will not repeat this, that since can I answer this question? Last judgment is Competition Commission of India versus Steel Authority of India, 2010, volume 10. Serial number 2010, volume 10 SCC, 744. CCI versus Steel Authority, 2010, volume 10 SCC, 744. This judgment was on the aspect that reasons have to be given. I'll be referring to paragraph 97, 98. Where the Supreme Court has said that section 26(1) is the stage where reason should have been given. Take only half minute work by reading this paragraph 97 and 96. You're reading paragraph 90, paragraph 97. The above reasoning and the principles enunciated, which are consistent with the settled canons of law, we would adopt even in this case. In the backdrop of these determinants, we may refer to the provisions of the Act. Section 26, under its different subsection, requires the Commission to issue various directions, take decisions, and pass orders, some of which are even appealable before the tribunal. Even if it is a direction under any of the provisions and not a decision, conclusion, or order passed on merits of the Commission, it is expected that the same would be supported by some reasoning. At the stage of forming a prima facie view, as required under section 26(1) of the Act, the Commission may not really record detailed reasons, but must express its mind in no uncertain terms that it is of the view that prima facie case exists, requiring issuance of direction for investigation to the Director General. Such view should be recorded with reference to the information furnished to the Commission. Such opinion should be formed on the basis of the records, including the information furnished and reference made to the Commission under the various provisions of the Act as aforesaid. However, other decisions and orders which are not directions simpliciter and determining the rights of the parties should be well reasoned, analyzing and deciding the rival contentions raised before the Commission by the parties. In other words, the Commission is expected to express prima facie view in terms of section 26(1) of the Act without entering into any adjudicatory or determinative process, and by recording minimum reasons substantiating the formation of such opinion, while all its other orders and decisions should be well reasoned. Such an approach can also be justified with reference to Regulation 20, Clause 4, which requires the Director General to record in his report findings on each of the allegations made by a party in the intimation or reference submitted to the Commission and sent for investigation to so and so. Last paragraph. The inevitable consequences that the Commission is similarly expected to write appropriate reasons on every issue while passing an order under section 26 to 28 of the Act. So when they formed the opinion on 4/8/2020, the Commission has simply followed the observations of the CAG. It has not applied its mind. Otherwise, it would have said that MP Excise Act is the regulator, and under the MP Excise Act, everything has been provided. Why should we exercise our power if there is an independent regulator? And all these objections which I have raised should have been raised and at the time of formation of the opinion, whether we can exercise the power or not. It was not a case where a private entity was involved. It was an independent, parallel, co-equal regulator. And since it has not been done, it violates this paragraph said in the context of 26(1) of the Competition Act itself.
Any other way?
The last judgment is based upon the primary aspect of this matter, that this intoxicating liquor falls into the exclusive domain of the state government. My Lord, may kindly observe entry 8 and 51 of list 2. Entry 8 and 51 of list 2 deals with intoxicating liquors. 51, 8 minutes says so, madam, what I'm saying is that recently the Supreme Court has observed. Sorry, madam. Can I read entry 8? Intoxicating liquors, that is to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. This is the exclusive jurisdiction of state, not the central government. So CCI has no jurisdiction to ask state government to make or amend its policies. It will remain the jurisdiction of the state government. And this issue has been recently decided by 9-judge bench of not recently, in 2024. That is a judgment where we have uploaded as serial number 4, 2024. Volume 17, SCC, page 1. My lord, permit me to reserve my time for using this judgment. It's a judgment at the time of rejoinder of my submissions. My principal submission is that in this view of the matter, when the Supreme Court has categorically observed that Parliament cannot occupy the field of entire industry of intoxicating liquor merely by issuing a declaration under entry 52 of list 1, read with Article 246. Parliament does not have the legislative competence to enact a law taking control of the entire industry of intoxicating liquor covered by entry 8 of list 2. So this is a serious aspect of the matter.
The kernel or regulatory authority or something, whether this entry has a relevance.
Yes, definitely, ma'am. Because in case the Supreme Court says that Parliament has no power, and we raise this objection, we have raised this objection. Well, we have raised this objection, and they have not even considered in their reply, in the order. When the order on 20th of March was passed.
Entries are for making a law for
Definitely.
but kernel is supposed to be examined.
Can they transgress their jurisdiction? When this issue is taken up before the tribunal, suppose we are arguing before the CCI or
They
the.
will not bring the act and like we.
Definitely, but they can certainly decide the boundaries within which they can entertain, they can have the complaint and analyze that. They can say that this is beyond our jurisdiction. From that perspective, I would be referring to this.
Anything to it? Monday. Yes, Monday to Friday.
It's okay.
क्या नाम बताया? You can join a group if you want.
I would be coming on a person. It's always a pleasure to be here. Great.
Item number 41, please, Hers Diwali.
The corpus, you see.
And my lords, in this, it can be kept on any of the date. I'll argue it finally and file the rejoinder if so required. My lords, I'm also praying for the interim relief. In this petition, interim has not been granted, and in the my lords, I have uploaded the orders, identical orders, where my lords have also extended the benefit of interim relief in the reference. Also, my lords, I am carrying the printout if my lords may allow. Sixteen point one. 13174 2026.
My lords, the reply of the state is awaited, my lords. That may kindly be filed in the meanwhile.
Reply has been filed.
Well, there was, since the amendment was made to the petition, my lords, and the rules were challenged, the state government themselves had sought on an earlier date, my lords, time to file reply. My lords, may kindly have the previous order sheets of the matter. On 8/4/2026, my lords, the state government had sought time.
You may adopt the request.
My lords, that will suffice.
Office to that. Also to be. Reply filed by the state in one of the commissions to approve it. Yeah. The state is government there. Except for the release.
The interim relief, my lords, in my case may also be continued. But
It's a leased out land since 1926, my lord. It was time and again lease was, my lord, renewed and extended for 30 years, my lord. Thereafter, in 2007, the family did partition of the property, and after in 23-24, we purchased this land. This was a Nazul land, my lord. After we purchased the land, we moved application. We moved an application, my lord, for छोटा सा matter, my lord. It is only, my lord, due to, my lord, adamancy of the collector, my lord, we are suffering, my lord. My lord, may hear me for 10 minutes if my lord thinks, my lord, that it is a matter which would take time, my lord. उसके बाद हम इतना सा है कि लीज होल्ड राइट हमने खरीदे थे, नजूल लैंड की इसकी एप्लीकेशन कलेक्टर ने मूव करी कि इस पे परमिशन दी जा सकती कि नहीं। हमारे पास नजूल की परमिशन है और टीएनसीपी की सारी परमिशन है, सिर्फ म्युनिसिपैलिटीज की एक परमिशन के पीछे का इशू है।
May I please below item number 19? Are my lords able to hear me?
A bunch of more than 20 cases. We take up or any other one.
My lord, there is one request here. It was remanded back by the Honorable Supreme Court, my lord, almost 1.5 years ago. The issue is very simple. If I can just take 1 minute by clock, I won't take more than that. The issue is very simple. I'm sorry, my lords.
Are you agreeing on all the bunch of matters?
Well, I'm appearing in the main matters. The issue is common in all of them.
But other councils are not available. You have made a request for out of penalty. Let the other council come, then we will take.
Would my lord consider taking it up today? Because the reason is this. I understand that tomorrow onwards there's holiday, my lord, but there's some difficulty in this matter. Can I just take 30 seconds? Not more than that.
Okay. You can withdraw.
In the main matter, 19.
Because what has happened?
There's the Supreme Court order.
I'm sorry, my lord.
There's the Supreme Court order, remand order.
The remand order, we attended a compilation last time, my lord. That has an order of the Honorable Supreme Court by which the matter has been remanded back.
Are you ready for petitions? For petitions. Let the Supreme Court order, remand order.
And the world asked for the 50
Not remand order. There a remand who can
My lords, kindly have the 18th December 24 order. 18th December 24. Post that, the matter has been restoured by this honorable court. 18th December 24 is the Honorable Supreme Court's order.
Where is that order, Mr. Counsel? Nobody is showing that order.
I tendered a compilation, if my lord can just have that. 1 second.
ठीक है, तो number आ रहा है.
In fact, this matter is listed on 9th of August, the order
9 September.
in the Supreme Court.
No, I'm sorry. We have only filed that application in Supreme Court. That has nothing to do with this matter. In fact, that is for an early disposal here, where notice has been issued that the matter should be disposed of in an early date convenient to my lords. I understand, my lord. Can it just be passed over? We'll keep out the copy ready, my lord, and we'll tender it. Can it just be passed over for at the end of the board, my lord?
The counsel, you started arguing that Supreme Court has remanded this matter.
Indeed, my lord.
Where is that?
18th, on the last occasion, my lord, there was a compilation tendered. The first annexure in that is the remand order. I'm just requesting my counsel there in the court to hand over the compilation, my lord. Last occasion when the matter came up, we had tendered a compilation of all the relevant orders.
Okay.
One second. Devesh Sharma.
Supreme Court में तुमसे no आठ पर सबूत लगी हुई है.
Mr. Sharma, please address us. We are.
I'm just.
It's number.
Regular matter. We'll take a walk. In some petitions, my lord, reply has not been filed. Petitions are not complete. All these matters will be taken before the order.
Look, meetings are completed in this matter.
Let the registrar satisfied.
Well, would my lord consider giving us a short date, my lord? Because
Fix the date. Item number 30. You fix the date.
any short date if possible, my lord. I'm sorry, I'm pushing for it, my lord.
My lord, it's relating to GST on royalty matter is pertaining.
Item number 35.
My lord, petitioner is executing work, my lord, relating to construction of rail overbridges and rail underbridges with the railways. My lord, before I take this honorable court to the impugned order, my lord, just have a look at annexure P4, my lord. I want to show only two clauses, my lord. P4, it starts at page 32. I am taking this court directly to page 234, which is the special conditions. Digital also same, my lord, 234. P4 starts at 32. This is the entire tender document terms and conditions. Yes, I am at 234. Now 234, I'm just showing the headings, my lord. These are special conditions. Then page 323 may be seen, my lord. Now 323 is, my lord, specification for non-schedule items. P4, my lord.
400.
Yes, yes, the entire tender document, instructions to bidders, terms and conditions, special terms and conditions, everything is there. Yes. Now this is specifications for non-schedule items. Let's just skip a few pages. Please come to 328. Now, I have shown that this is under the special conditions head, my lord. And now come to 328, serial number 6 in the middle, my lord, mode of payment. Below the chart, NS, that is the non-schedule item, that is casting, supplying, transportation, launching precast reinforced concrete fascia panels of thickness 180 mm by so and so. Well, let me explain what is a fascia panel. When there is a bridge constructed over road, there are sloping roads on the both the sides, my lord, gradual gradient. The side walls are the RCC structure, the approach to the bridge. On the sides of the bridge, my lord, that slope, you have those RCC fascia panels, my lord, those bricks kind of structures, my lord, which are the wall of the side sloping roads, my lord, on the sides of the road. Now, this is a non-schedule item in this contract, and this is RCC fascia panel. Now, please see serial number 2. The item includes, yes, same. हाँ, उसके बावजूद वो बल्ज हो गया था शेपुरा में. That the soil maybe got moisture or something, it bulged and it cracked. But then the issue is slightly different here. Serial number 2, the item includes cost of casting, supplying, transportation, and launching in position precast RCC fascia panels of thickness so and so, including all labor, machineries, material, shuttering, cantering, vibrating, curing, etc. Now, the bold, except cement and reinforcement steel, which will be paid separately under the relevant US SOR 2019 item as per consumption required according to so and so. Now, the bold portion is, my lord, the special terms and conditions annexed to the tender and part of my agreement. Now, according to this, my lord, the cement and steel for these RCC panels, I have to do labor, machine, material, shuttering, cantering, vibrating, curing, etc. But these cement and steel under these special terms and conditions annexed to the NIT as well as my agreement, they are to be paid separately. Now, my lord, for 25 bills over about 2 years, I have been paid these items separately. Now, there is some audit issue arose, and now they have started recovering, my lord. Now, the order which is under challenge, before that, just see, my lord, the conditions at page 112. They are relying on this condition, my lord. Page 112, same annexure P4. Instructions to tenderers. PDF also 112 and numbered also 112.
Digital page 81, my lord.
81.
Digital page
81.
Oh, I'm sorry, my lord, 81. Now, please see, my lord, 1.01, that is the order of precedence of documents. Now, this precedence says 1, letter of award, 2, bill of quantity, 3, special conditions of contract. Now, please come to 1.1, interpretation. These instructions to tenderers shall be read in conjunction with the standard general conditions of the contract, which are referred to herein, and shall be, now this is important, subject to modifications, alterations, or supersession by special conditions of the contract and or special specifications, if any, annexed to the tender forms. Now, what the audit has raised an objection is on the first part of 1.01, saying that order of precedence is Roman 1, letter of award, Roman 2, bill of quantities, Roman 3 is special conditions of the contract. Totally ignoring 1.1, which says if there are special conditions of the contract, the general conditions will be subject to the modifications, addition, suppression by general conditions of the contract. Now, I have shown the special conditions of the contract in bold, signed between the parties, that the rates of steel and cement will be paid extra for these RCC fascia panels. Now, in light of this, ignoring 1.1 interpretation clause, which clearly says that the special conditions will have an overriding effect over all the previous general terms and conditions, And it clearly uses the word shall be subject to modifications, addition, suppression by general special conditions of the contract and or special specifications, if any, annexed to the tender. Now, my lord, there is an audit objection raised. No, I have two contracts. One is 95% complete and one is about 50% complete. They have paid 25 bills and that is recorded in the order, Annexure P2. That is recorded in the order that they have paid 25 bills and now they have suddenly started recovering based on audit objection, which सर 95% काम हो गया अब तो अगर सब रोक लेंगे तो हमारा the contract will vitiate and more than that settling will be later. My bank guarantee along with them is 5.25 crores and 2.46 crores. Lord, they are seeking to recover about 2.8 crores in one contract and 80 lakhs or 1 crore in other contract. Around 3 crores they are seeking to recover after 25 bills based on that wrong interpretation of 1.1. According to them, the special terms and conditions will have no value. Now, they have around 8. They will stop. Yes, recover from running. And they have around 8 crores of BG with them. And I am almost done with the contract. And now they say 1.1, that interpretation clause, that it will have an overriding effect, and normally also. Well, the general terms and conditions of the tender stand superseded by the special terms and conditions which are signed between the parties in the contract. And special terms clearly says in bold, I have shown, that the rate of cement and steel will be paid extra. And I have been paid extra for 2 years. Only interpretation of one line. That we have uploaded several judgments. Supreme Court says no. For this, I don't have to go for 10 years in arbitration. There is a one-line question whether special conditions of the contract will override the general conditions or not. That is the only issue. And that goes without saying, my lord. Any layman will say that a special condition of the contract, specially entered into for this contract and written in bold that they will be paid extra, these two items. That's the only case, my lord. Pardon? The impugned order is P2. P2 is the impugned order at page 28. The first para itself says 21st running bill. So 21 bills they have already paid in last around 2 years. And then they quote the relevant general conditions of the tender, not take into account 1.1, the special conditions at all, not to say the interpretation clause which says that that will be having overriding effect over the general terms and conditions. And then there is a direction to make recoveries against. And that's the only issue involved. They will not quantify, they will stop my running bills. So I am not even giving them the running bills, because the moment I give them running bills, they will adjust.
After your representation, where's the original demand? This is the adjudication of your representation.
Yes, there is no original demand as such, my lord. They issued.
The officer evaluated your representation. His representation against the proposed recovery. Where is the proposed recovery?
No, there is no proposed, my lord. There is annexure P1, which. No, pursuant to the audit objection, the vigilance objection. That is P1. I responded to P1. Yes, internal. And there is no independent application of mine, my lord. There are already case laws which say that audit objections cannot be the basis for impugned decision unless there is a full application of mind. They are different, auditors are different accounts people. They don't interpret the contracts. And in para 3 of this, they note that it was allowed by relying upon the special conditions of the contract. Para 3 of this objection may be seen. Examination of the contract documents revealed that BOQ item clearly envisaged inclusion of all materials in the rate of the aforesaid non-schedule item. However, during execution, the separate payment towards cement and reinforcement steel was allowed relying upon the special conditions of the contract.
My lord, there was a vigilance inquiry, my lord, if my lord may see annexure P1. And admittedly, my lord, this is during the vigilance investigation of the contract of construction of 3 numbers of ROB number 5, 6, and 7 between Ghatoli and Khilchipur station of WCR. It was observed that separate payment towards the cement and reinforcing steel was made to the contractors under the NS item relating to design, supply, and erection of precast RCC fascia panel, despite the BOQ description of the item clearly specifying that the item rates was inclusive of all material, including reinforcement cement. And thereafter, my lord, the recovery was initiated, my lord. And in fact, my lord, if may see, admittedly, my lord, annexure P3, annexure P4 is the contract between the parties. Clause 64 provides for arbitration. They have availed the mechanism, they have availed the conciliation, and then they have submitted representation, which was rejected. Now there is a procedure, alternate dispute redressal is there, my lord. They can very well go for arbitration for this. It's a contract matter between both the parties, my lord. And with open eye, they have entered into a contract with us. My lord, may kindly have clause 64 of the contract.
Well, there is no dispute that there is a clause, but the issue here is when it's a question of only interpretation of one paragraph consisting of 4 lines, then it is not an issue which has to go in arbitration. Then the writ court, my lord, from Godrej, Sara Lee to my lord, ABL International to Unitech, we have uploaded all the judgments where Supreme Court says, where it is a question of interpretation. And even if for going into some evidence, the High Court should not send it to the alternate forum. And here there is nothing, my lord. I am only showing 2 pages, 112 and 323. 323 page clearly in bold special conditions say that these items are to be paid extra. My lord, I offered by bid with this condition that I will be paid cement and steel extra. This is a condition annexed to the tender. So I offered my bid knowing that the cement and steel will be paid by them. And I was paid for 21 bills. Now they cannot revert to the general terms and conditions of the contract, which according to page 112 stands superseded by the special terms and conditions.
When there is the use of cement.
Yes. So cement would.
Of this panel, why you are cleaning cement?
No. Under the special terms, 323 आप देखें.
RCC panel.
हाँ.
Wait from the cement.
No.
No extra cement is required for.
No extra. But at page 328, just have a look. I am reading that para 2 again. Now, this special condition is a part of tender. So, 328 page, the special terms and conditions, para 6, para 2, I was reading. Just have a read. So, in my tender, I was to bear the cost of casting, supplying, transportation, launching, including labor, machinery, material, shuttering, catering, vibrating, curing, except in bold, cement and reinforced steel, which will be paid separately under the schedule of rates 19. So I have been paid, my lord, according to the RCC fascia panels I have made, I have always been paid cement and steel extra as per the schedule rates of cement and steel.
So further, as per the consumption required according to which design
duly approved by building for.
इस मतलब जितना जितना सीमेंट लगेगा आपको उतना ही दिया जाएगा, वही दिया है उन्होंने, वही दिया है हमको, उन्होंने वही हमको अभी तक दिया है, वही हमको, एंड नाउ दे आर सीकिंग टू रिकवर. So the cement and steel which I have already got under this clause 2 of the special terms and conditions for 21 running bills.
About how much payment has been made and how much they have to recover. अभी तो केवल एक objection है.
वो Milord, we have annexure P2 only directing the authorities to. Milord, we have assessed as per the amount paid till now, Milord. We have assessed ourselves because our 21 running bills. Milord, the amount is not the issue. They may recover 1 rupee or 1 crore. Milord, amount is not the issue. Whether they can recover or not, that is the issue. The issue is not amount. Whether they can, despite special terms and conditions, providing.
Access, then the concrete actually required.
It is nobody's case. It is nobody's case that I have been paid extra. It is nobody's case. नहीं, but ये NS आइटम है, नॉन शेड्यूल आइटम है, इसलिए इस नॉन शेड्यूल आइटम का उन्होंने ब्रेकअप किया था. लेबर एबर सब आपकी रहेगी, हम स्टील और सीमेंट हम देंगे आपको, और अभी तक जितनी क्वांटिटी लगती आई है, आई हैव बीन पेड सीमेंट एंड स्टील सेपरेटली.
क्वांटिफिकेशन कहां पर होगा
सर? वो रनिंग बिल्स में से रोक लेंगे,
तो कैलकुलेट करेंगे भाई कितना ऐसा थोड़ी.
Milord, we have given approximate, Milord, in our petition also. Milord, we know 21 bills how much they have paid under this head. We know that amount, Milord. जी नहीं सर, एक नहीं है, 10 और 3 13 है, 13 ब्रिजेस है, जिसमें से हाँ वो जो दो स्लोप्स होते हैं दोनों तरफ, वो करीब करीब 400-500 मीटर के एक तरफ होता है दैट स्लोप ग्रेडियंट. उसके पूरे ट्रायंगुलर शेप में जो पूरे फेसिया पैनल्स लगते हैं. तो आई हैव बीन पेड फॉर 21 बिल्स फॉर सीमेंट एंड स्टील. नाउ दे कैन नॉट, एंड otherwise what will happen to the special terms and conditions of the contract? And the issue is only this. So we have, Milord, given the amount, what this court is asking. We have already given the amount in para 5.25, which is the amount which we have received under this head, and which now pursuant to P1 and P2, they will recover from my running bills. We have already given the amount, Milord. It's around 3, 4, 5, 6, around 7 crores, Milord. $6.75 crores. No, I don't have to wait for quantification because Annexure P2 directs them to recover from, make recovery from me. So, Milord, my submission here is, it cannot be said that since there is no quantification, probably the petition is premature. It cannot be said because the amounts have already been paid in 21 bills, which in para 2 of the Annexure P2 they say. I have given the details of that amount which they have already paid to me. Milord, it takes months and months. Milord, Lordship, may see what the Supreme Court. Milord, if they file reply, this issue would have been decided with this argument at this stage only, Milord. That is what Supreme Court says, Milord. And we have uploaded the judgments. Lordship may just see, Milord, what the Supreme Court says in this situation.
But at present you need only injunction. बाकी तो जब वर्क कंप्लीट होगा तो अकाउंट सेटल होगा. At present you need only injunction. It is not एप्लीकेशन तो होना नहीं.
Adjudication will take after completion of the work.
No, there is no adjudication is P2. No, excess is nobody's case. Milord, if it is held that special terms and conditions will have no bearing, no value, then it's a different case. The moment this court says between the parties, if special terms and conditions are put to tender, I offered my bid with the stipulation and taking into account that cement and steel will be paid by them under special conditions for this particular work. They have paid me for 21 running bills. Now, because of audit objection, suddenly that recovery being made against me and the amount is quantified in my para 5.24, my lord. I have already quantified the amount because I know what I have been paid. My running bills, my lord, I have been paid these two items separately, depending on the work that they got executed from me. So I am aware of the amount. The moment, my lord, I give my running bill, they will deduct that amount. And after they deduct my amount, my lord, then it will be too late for me.
Non-scheduled item.
So that is why it is to be paid extra. Agar scheduled item hoti, to that would have been different. So this was something not contemplated in the tender. That's why they said, आपको labor सब आपको करनी है, हम आपको steel और cement देंगे. So my submission here is that ABL भी है. Now, my lord, just see what Supreme Court has to say, my lord. First judgment, Godrej Sarali, that is 2023 SCC Online SC 95, para 8, last 7-8 lines, my lord. After considering Supreme Court decisions, my lord, it is said in the latter decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant through the mill of statutory appeals in the hierarchy. What follows from the said decision is that where controversy is purely legal one, and it does not involve disputed questions of fact, but only question of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternate remedy being available. Exactly same situation. I am only saying interpret 2 pages, my lord, and 2 clauses, and especially the special conditions. Now, my lord, second judgment, ABL International. Just see what Supreme Court says where in cases of special conditions of the contract. Now, ABL is, my lord, 2004, volume 3, SCC 553. Page 41, para 41, ABL. This was a case similar to the present one. Here it is termed as special conditions of the contract. There before the Supreme Court, it was addendum to the original contract, replacing and substituting and amending the existing clauses. That Supreme Court says, my lord, this addendum replaces the original clause 6, and from the language of the addendum, it is clear that addendum clause 6 becomes an integral part of the original contract in place of original clause 6. The language of the addendum clearly shows that the payment of consideration by barter supply of goods was no more sole mode of consideration. And if for any reason whatsoever such a payment by barter did not materialize between the parties, then the payment had to be made in US dollars. In our opinion, there can be no 2 possible interpretations as to the meaning of this amending clause. So this is what exactly I am saying by referring to clause 1.1, that it says in bold that you will be paid extra. There can be no second interpretation. This is what my submission is. And for that interpretation of 3 lines and at only 2 pages, 112 and 323. 112 is the general conditions, containing the interpretation clause, and 323 is the special conditions which, as per page 112, that is the 1.1 interpretation, that it will have an overriding effect. And even otherwise, there was no requirement of having a clause like 111, 1.1 at page 112, because special terms and conditions will always prevail over the general terms and conditions. But here it is categorical that they will prevail. And then serial number 9, State of Bihar, it's a case of audit objection and similar action being taken. Supreme Court says audit objections can't be the sole basis of taking a decision. One could understand that they had interpreted clause 1.1 interpretation. They would have said that despite a special condition, despite writing in bold that you will be paid extra, for these XYZ reasons, you will not be paid extra. One could understand. And in the serial number 9 State of Bihar judgment, it was a case where the audit report formed the basis of impugned action. So the Supreme Court says, my lord, that the authority cannot rely basically and solely on the audit objection, like in this case. No. I'm sorry. I'm sorry. This one. Yeah, that's it. Six point two. Mode of payment, mode of payment. Office payment, RTP payment. So, Guru, you also say, Mother. In detail, 11, page 298, 329, sir. This is the 29. I think you need to follow it. तो आपने रोमन में भी लिखा हुआ है एक्सेप्ट सीमेंट एंड एनफोर्समेंट रोमन 2 और फिर सीमेंट का स्पेसिफिकेशन भी दिया है। हाँ, ये वाला यूज करना है।
553 ग्रेड
That's why you are aware that the submit is extra.
Well, if my lord, you see the annexure P1, it says that the extra which has been paid to you.
हाँ तो आपको कहना कि इसमें सीमेंट और इसका नहीं मिलेगा आपको that you will not get the amount of the cement and reinforcement scheme. इसका objection है but this is extra to panel. और तो पैनल का ऐसा जो मैग्नेटिक अपने आप की पकड़ है तो सीमेंट से और रॉड से जोड़ना तो पड़ेगा मतलब जब वो गिर जाए टाइल्स कैसे लगाते हो आप
But my submission in this case,
इसके पीछे भी सीमेंट और वो लगता है ना एडिटिव
well, my submission in this case, they are saying there is an interpretation of contract terms and clauses, my lord. Clause 63 provide alternate disputes, my lord. It's purely a contractual matter, nothing less, nothing more, my lord.
then wait till the end of the why you are making a company during the then wait till conclusion of contract.
And they have 7 crores bank guarantee with them. 7 crores.
पानी यूज करेंगे तो फिर पैसे क्या मिलेगा
Look, they can raise.
the act is not recover so you will have to wait till the conclusion of contract फिर आप सेटल होगा कौन also how to make it the same can be doing also which mode of business payment for there is a plastic supply transportation launching in car import the company to be a parent. Will include both the property, supply and transportation and except cement and reinforcement. Under this clause, payment to the export. Now the officer of the market is the amount of liability. The additional home guarantee worth of 57 crores. That is the recovery from learning system. It was the effect of what? Technical and the further from there is appointed. As the authority and power to make a recovery after consisting of level. So for access of the recovery, so the same so point
My request is within 2 weeks, we'll file reply. My lord, may list it for any date, we'll finally argue it.
2 weeks. Very good.
Except the cement and reinforcement.
Very good. Well,
Item number 38 has additive Srivastava.
Before my learning starts with the arguments. The impute order is of 12th of August. I filed a caveat on 13th August. My caveat number is 2764 of the.
We have supplied copy bill.
But somehow it could not get ring fenced.
इसमें दूसरे
I was surprised today in the morning that this matter got listed. So I'm just seeking a week's time. My caveat was filed on 13th August. It's 2764 of.
The blacklisting is not very effective, my lord, from today.
By the registry.
Blacklisting has become effective, my lord. And I will show, my lord, how, my lord, they have blacklisted us. Blacklisting.
I'm just seeking a week's time. My caveat was there on 13th August. We filed 276.
There is a next tender is, my lord, on 4th, my lord, then I will be, my lord, not able to participate. And I will show, my lord, how mechanically. Blacklisting order is, my lord, P15. 38. I will show on merits also, my lord, and also how, my lord, they decide the cases of blacklisting. The show cause notice and calling reply is, my lord, just a formality. They don't even, my lord, make even a whisper of, my lord, the reply in the final order of blacklisting. Just a formality that you show cause notice, you file reply, but for what purpose the reply is filed? If your lordship will see, my lord, the show cause notice and the impugn order, my lord, it is almost the same, except the operating part. Yes.
13, 10 days and all.
Lord, the fourth is, my lord, the next. Pardon me? My lord, the next tender, my lord, I will not be, my lord, in a position to, when is the next tender? Fourth. That is uploaded, my lord, in the ERP. And I will show, my lord, it is, my lord, totally, my lord, there is a condition in the, my lord, contract, tender, that before taking delivery, they will make all the inspections. एक की निकल गई, दूसरे की अभी है ना. I have already suffered it once. 4-9. 2 tenders we have already missed.
I'm trying to find the reply.
The lordship with just will not give me 10 minutes, will I will show, but this can't be sustained. Caveat is, Lord, not for asking time. Caveat is, Lord, that they will be heard. They can oppose this.
Just came to me today in the morning.
If your lordships are, Lord, caveat, purpose of caveat is if lordships are convinced, my lord, then before passing any interim order, they will be heard. It purpose is not, my lord, for adjournment.
They can effectively oppose by bringing document or by bringing some sort of reply.
If your lordship gives me 10 minutes, I will show, my lord, how they have done it.
But he is not ready, then
Because
there may not no order.
the registry could not link my.
Ask him to file a reply. We'll take up a discussion by the time it's filed short of.
We'll file a short.
After 4th date, here on stay on that.
But the submission of tender, my lord, itself is a, my lord, very difficult task. We have to prepare everything. We have to, my lord, prepare declaration, etc., etc. That is to go with the tender.
Tender with the same authorities.
No, ये किसके साथ है? ये उत्तराखंड का है. उत्तराखंड में हमको सबमिट करना है उसको. सारे डिक्लेरेशंस देने पड़ते हैं उसमें. In the next matter, I will show, my lord, that is the point in the next matter. एक दिन की उस पे इधर उधर हो जाए एक लाइन में तो क्या डिस्क्वालीफाई. पढ़े मिनट. आजकल सारे टेंडर्स में रहता है बाय एनी गवर्नमेंट, एनी पब्लिक सेक्टर. ये तो आजकल सारे टेंडर्स में. ब्लैकलिस्टिंग में आपको इतना क्या प्रॉब्लम है भाई? अगर रिकवरी होती, आपको पैसे मिल रहे होते तो बात दूसरी थी. इतना पोस्ट कर रहे हैं वो तो ठीक है. ब्लैकलिस्ट
It could not get connected, man. Otherwise, there were short instructions.
जरा सा B15 को जरा से देखे जरा एक मिनट.
The morning that the petition is filed by the AG office. My caveat was filed on 13th August 2764 of 26, but it could not get
एक
linked
सेकंड
with
के लिए जरा इम्प्यून ऑर्डर भर देख
the
ले.
petition, man.
इम्प्यून ऑर्डर एक सेकंड के लिए भर देख ले.
Technical fault on the part of the registry.
वेयर इज द कंसिडरेशन? आप लास्ट में देखिएगा, लास्ट पैराग्राफ पेज 219 पे, उक्त के संबंध में कार्यालय द्वारा पुनः पत्र क्रमांक 100 के माध्यम से फर्म को कारण बताओ नोटिस जारी किया गया, जिसके परिप्रेक्ष्य में फर्म द्वारा प्रेषित जवाब के में उक्त उपकरण में लगने वाले ट्रांसड्यूसर केबल को प्रदायित किए जाने का उल्लेख किया गया, जिस हेतु फर्म द्वारा प्रस्तुत जवाब मान्य नहीं था. तदोपरांत कार्यालय द्वारा पुनः पत्र को समाज को लिखकर माध्यम से उक्त उपकरणों की संपूर्ण मात्रा का 20 कार्य दिवस के भीतर रिप्लेसमेंट किए जाने हेतु निर्देशित किया गया, जिसके परिप्रेक्ष्य में फर्म द्वारा अभ्यावेदन प्रस्तुत कर उचित समाधान किए जाने के संबंधी लेख किया गया, किंतु उक्त उपकरणों के रिप्लेसमेंट नहीं किया गया जो मान्य योग्य नहीं है. उसके बाद सीधा ये क्लॉज कोट करके वो कर दिया. वेयर इज द कंसिडरेशन ऑफ माय रिप्रेजेंटेशन? रीजन क्या है? सप्लाई जब हुआ है, देयर इज 2 different portions of the Milord tender. One is about Milord, before taking delivery, they have to inspect everything. And after the supply, when it is operation, then there is a Milord condition of warranty. I just, my lord, in the simple terms, my lord, I just give it like this, my lord. Suppose, my lord, an organization, my lord, says that we have to buy 10 Toyota cars or Toyota vehicles. They ask the dealers to submit tender. They are not the manufacturer, my lord. Now, before taking delivery, my lord, then they will see everything. After the delivery, my lord, there is a warranty conditions. After 4 months, 5 months, 6 months, if there is any defect, my lord, which is pointed out, then there is a warranty, they are bound to do it. Similar is the situation here. Kindly see, my lord, page 62 and my lord, page 65. And report, my lord, they don't consider, my lord, even the report. Report doesn't find that the equipment is faulty. It only needs an additional instrument which they don't have. I said, I will give you free. Kindly come to page 62 for a moment. Here, my lord, it is the inspection before delivery. 11.8. A to D. Lord, I will not be able to, my lord, file, my lord, my tenders. Then your lordship, then your lordship may take up on first. Your lordship may take up on first, my lord. सारी कन्वीनियंस तो नहीं देख सकते. But can it be, my lord, high on the, my lord, board so that, my lord, can it be high on the board or top of the list? Because that day your lordship have kept, my lord, one matter at 2:30. That Soon Distilleries matter, my lord, Mr. Kamath is appearing. That would be difficulty, my lord. Lordship may say, my lord, top of the list. Lordship may, my lord, top of the list. नहीं सेकंड फर्स्ट यहाँ से जाना सब कराना सर्टिफाई कराना हमारी रिक्वेस्ट
छुट्टी भी चाहिए पूरा कंटिन्यूस हॉलीडे चाहिए बर्डन हमारे ऊपर है.
योर लॉर्डशिप में टेक अप ऑन फर्स्ट क्योंकि डिक्लेरेशंस वगैरह सर्टिफाई भी कराना पड़ता है. ये सब करना पड़ता है. 2 दिन से ऑनलाइन प्रोसीजर फर्स्ट your lordships will also have, my lord, some time to rest, my lord. I know how much work they have to do, my lord.
Nowadays, trending is
First,
on.
my lord, with liberty to make a request. On first, my lord, on first.
Yes. 39.
Condition.
Before my senior starts, they are on caveat in this. This petition is filed on the.
Here, my lord, they will award the contract, my lord.
Plus the premise.
And I will show, my lord, when they want to, my lord, award, my lord, contract to somebody, how they, my lord, just ignore, my lord, the tender condition, which are the essential conditions.
Just one submission.
My lord, there is a condition, your lordship may kindly come to, my lord, 130. Or how, my lord, they ignore this? And my representation is rejected by an officer who is not competent. Kindly come to, my lord, page 130 for a moment. 130 clause 5, article 5. On 3 counts, my lord, I am challenging my.
It's a matter of termination of contract.
No, my lord, award of contract.
Award of?
Award of contract. To, my lord, respond number 4.
You have not been awarded a contract.
I am L2, my lord, he is L1.
L1 को दिया. L1 को दिया.
L1 को दिया.
But he was not qualified, my lord. Kindly see, my lord, this. Article 5, my lord, page 130. An admitted position. And how they are ignoring it.
ठीक है, इसमें बेनिफिट क्या है?
नहीं अवार्ड कर देंगे तो फिर वो आ जाएगा इक्विटी इनका कि हमारा तो काम शुरू हो गया, ये हो गया, वो हो गया.
Because award has already been made was my submission. Because in page number 9, they said that award has not been done as yet. Because page number 9 of their petition, this petition was filed on the premise that LOA or concession agreement has not been executed. Because I'd respectfully submit, I'd uploaded the LOA in reference. The LOA was issued on 31/7, almost a month ago. And the successful bidder has also accepted that.
Is there execution of contract and work order is given?
Yes.
हाँ.
So that will take time.
एक शुरू करेंगे तो फिर उसका वो होगा कि भाई
Right to
equity.
Yes.
Your lordship may, my lord, just observe this, my lord, till next date of hearing. Subject to, my lord, interim order will be considered on the next date of hearing, but nobody will claim any equity on.
तो ऑलरेडी लगा है ना लोग क्या है एक्सेप्टेंस भी हो गया है.
हाँ लेकिन वर्क ऑर्डर वगैरह इशू करें, काम शुरू करें, they will not claim any equity. None of them will claim any equity.
62 किलोमीटर के 2 डे पोर्ट.
लेकिन देखे तो सही, 2 मिनट जरा सा देखे तो अभी आपको समझ में आ जाए. पेज 130 पे 1 सेकंड जरा आएंगे, जरा पेज 130 पे 2 काउंट्स में इन लोग कैसे उसको वॉयलेट कर रहे हैं. बिल्कुल पेज 130 आर्टिकल 5. The bidder declares that no previous transgressions occurred in last 3 years immediately before signing of this integrity pact with any other company in any country conforming to the Anti-Corruption Transparency International TI approach or with any other public sector enterprise undertaking in India or any government department in India that could justify his exclusion from the tender process. So in last 3 years, they have not been transgression. Kindly straight will come to below page 667. This is the 667. There were charges of corruption, my lord, against the employees as well as, my lord, the company for bribery. And for that, my lord, the Ministry of, my lord, Transport and Highways, by order dated 18 September 2025 in the last year, my lord. Kindly come to, my lord, operative part, page 667. This is the order passed. Having, your lordship got it, my lord? 667. Having examined the matter in detail, I am of the considered view that the 2 companies are the responsible for serious violation of the Integrity Pact at the hands of the employees who held considerable power and position in the company's hierarchy. Accordingly, Messrs. Bansar Pathways and Limited, as well as Messrs. Bansar Construction Works Private Limited, both with registered office so and so, Kamalapati Railway Station, Bhopal, so and so, are hereby disqualified from participating in any tender process of the Ministry of Implementing Agency up to 39/25 with effect from date of filing of FIR CBI. So, debarment is there, but it was for a limited period. Condition which I have shown is below, it says that in last 3 years, you have not been debarred. When I raise an objection, below, that is rejected by saying that since this period has lapsed, therefore this is not a disqualification. Condition is that it must be operative. Condition is that in last 3 years you have not been debarred. The second thing is, my lord, there is another point. Yes, second point is this. Second point is, my lord, it says in two different clauses that there is no criminal investigation pending. And there is another clause, my lord, which says, my lord, there is no indictment or conviction. I submitted an objection that in this case, which is the submitted by the CBI, there is, my lord, charge sheet which is filed and which is trial is pending. What they say that the clause says investigation is not pending. And they totally ignore, my lord, the other clause which says, my lord, about refers about the indictment. Exactly, my lord, the same respondent, verbatim same contract, and there is a judgment by the Supreme Court, my lord, interpreting those clauses. Justice Nariman.
Uploaded in the reference.
This is uploaded, my lord, in the reference. The state of MP versus Uttar UP State Bridge Corporation. Paragraph 27. Same department, exactly same contract for same purpose. Paragraph 20. It is clear that Shri Dhru Mehta is right when he refers to and relies upon the aforesaid judgment in character in forte for the proposition that where there is a formal format which has to be strictly complied with, his client was justified in going by the literal reading of the aforesaid format, which only required a disclosure of pending investigation under clause 7B of Annexure 1 of NIT. However, as has correctly been pointed out by Shri Saurabh Mishra and Shri Puneet Jain, clause 7B of Annexure 1, which is in terms similar to para 13 of Appendix 1A, must be read together with para 11 thereof, which, as has been pointed out herein above, requires the bidder to certify that in regard to matters other than the security and integrity of the country, the bidder has not been convicted by court of law or indicted. Clearly, in the facts of the present case, though the investigation is no longer pending and though there is no conviction by a court of law, USBC has certainly been indicted in that a charge sheet has been filed against it relatable to fire number so and so in which a trial is pending. Though stated by the High Court, also Shri Saurabh Mishra is correct in stating that the fraudulent practice as defined in clause 4.3b of the NIT would include an omission of facts, exactly same thing, Lord, here also, or disclosure of incomplete facts in order to influence the bidding process. In the facts of the present case, there is clearly an omission of a most relevant fact and suppression of the same fact, namely that a FIR had been lodged against so in respect of the construction of the bridge by it, which has collapsed and in which a charge sheet has been lost. Here also, my lord, the charge sheet is, my lord, lost. The impugn order itself, my lord, records that. But what they say, investigation is not pending. As if, my lord, investigation is more serious matter than, my lord, a charge sheet which is pending in the court. Investigation will ultimately result into, my lord, either, my lord, giving clean sheet, my lord, or it will result into, my lord, charge sheet. And this is how, my lord, they reject my application. And your lordship may also see, my lord, page 719, who rejects my application representation, my lord? Tender inviting authority is managing director. My representation is to the managing director. And they get it rejected from the, my lord, chief engineer. On all this is Ipsy Dixie. Paragraph 1 itself says, my lord, however, the criminal proceeding of the impugned order arising out of the said final reports are presently sub judice before the competent court. Therefore, the declaration furnished by the bidder regarding pendency of investigation cannot be held to be factually incorrect.
MPRTC. Well, it's MPRTC because what had happened in this case is that there was a representation made by the petitioner to the MPRTC that we have rejected, and therefore we are in caveat with it. There's one material difference which in relation to the judgment which my learned senior had cited, Millets. Page number 653, the paragraph number 27, which has been read over. In the facts of the Honorable Supreme Court, while considering this, held that there was an omission of the most relevant fact and suppression of the same fact, namely that an FIR has been lodged. In the instant case, as per the document that I have received in the petition, Millers, page number 139,
So
the concerned bidder himself
that is in
disclosed
fact my ground.
himself.
That despite that was disclosed, the authorities could not have accepted it.
But then
And my representation is rejected, saying that investigation is not pending.
And there is no suppression per se. So that is the aspect which may be considered by a lordship's Millers. Secondly, LOA was issued prior to filing of the petition, Millers. LOA has already been
Misrepresentation, how we said when they submitted it, clause 11, they said that it is misrepresented.
In response to these on caveat, in the final reply justifies yourself, although by receipt feedback there is a defect. How the temporary exception was discussed later on.
Yes, please.
No. The clause
Clause
is that you have not been you have not been blacklisted or debarred in last 3 years. That is below.
If your lordship deem appropriate, notices may also be issued to respondent number 4. 4.
But the award, the contract will, award of contract will be subject to result. Pardon?
Notice to जाएगा.
हाँ वो तो है, interim में award of contract will be subject to result of the.
That is one, the phone number. LOA has been issued to phone number 4, and in turn, the phone number 4 has submitted an acceptance. दो बार ठीक है, 2 contract, 2 contract.
एक contract, एक ही.
One contract.
दो में
Millers, one is LOA, one is the LOA acceptance.
अभी agreement execute नहीं हुआ है इसमें.
दो LOA है, 4 और 5, 4 और 6 में अलग अलग लोग हैं.
वो रिपीट हो गया. एक शेयर टू ऑल और एक प्राइवेट में वो रिपीट हुई.
एक ही रोड है.
एक ही.
यस,
एक ही है.
Award. Sufficiently being decided perfectly. Final up. Item number 40.
How that?
With my lord's permission, my lords, we are assailing the teachers, item 40. We are assailing the notification notifying teachers' eligibility test in the state of Madhya Pradesh, which is proposed to be conducted on the 12th of October. The forms have to be filled up till 4th of September. My lords, our grouse is solely based on the fact that the state government, while implementing the Supreme Court order, which forms part of the instructions, does not read para 168, which clearly stipulates that teachers who were recruited prior to 2001, 3rd September 2001 is the cutoff date. Any recruitment prior to that does not have to appear for a TET test. And my lords, the notification, the 2 notifications are omnibus. They say anyone who has not. Please, my lords, we are an association. My lords, because there are at least 4,000 people in this association itself, Shiksha Karmis, who were recruited in 98. In fact, we are also drawing. Please, my lords. Please, my lords. The registration certificate is at annexure. No. My lords may have P10. That's the registration certificate. In fact, another petition we have filed is already pending before this honorable court. It's been adjourned sine die because my lord, the Chief Justice's order has gone to Supreme Court while my lord was presiding a bench in Indore. Courtesy that judgment of my lords, state government has gone to Supreme Court and every single petition with respect to deciding the seniority, the service tenure of Shiksha Karmis is pending before Supreme Court, and the Honorable Supreme Court has not stayed that order. We filed that also. It is my lords who's noted. This is at P1 and P2. P1 is where the government says kindly conduct the exam, and P2 is on 17th of August. The Professional Examination Board has notified the exam.
This is in compliance with the Supreme Court order for September.
My lords may have that order. That order is annexure A3, Supreme Court judgment. A3, P3, A3 at page 77. And my lords may have para 168. This is at page 111 of the paper book, printed page 111. What I am placing reliance on, and also the NCT notification. I'll take my lords. My lords has para 168. NCT's notification also reinforces this requirement, and the requirement is TT, by stating that teachers working in unaided private schools or those already in position as of 31st March 2015 must qualify TT within stipulated time. The language of both RT Act and the notification leaves no room for ambiguity that even those teachers appointed prior to RTE, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. And my lords may then have my lord's order of 17th of October. This is annexure P6, page 138. Shiksha Karmis were recruited after the Panchayati Raj system was introduced by way of a constitutional amendment. State governments were given the power. The power was delegated by government of Madhya Pradesh to its local bodies to recruit teachers. Those rules were formulated in 97-98. And my lords, at page 138, our friends and colleagues from district Mandsaur had won the writ. Nagar Palika Parishad Mandsaur had approached my lords in a writ appeal. My lords has page annexure P6. My lords may have para 2 of my lord's order at page 140. The date of recruitment, I am prior to 3rd of September 2001. Hence, I do not have to appear. Even the Honorable Supreme Court says so. My lords has para 2. Facts of the case are that respondent number 1 writ petitioner was appointed to the post of Shiksha Karmi grade 1 by an order dated 10/8/1998 issued by CMO Nagar Palika Mandsaur. At the time of the appointment, and service conditions of the writ petitioner were governed under the provisions of Madhya Pradesh Nagar Palika Shiksha Karmi Bharti Tatha Seva Shart Niyam 98. The entire cadre of Shiksha Karmis was recruited in 98. Everyone had their, and I read the Supreme Court order. 168.
214. For the detailed expression about
Everybody has to pass.
My lords, that para 168, my lords read. My lords may have reference. In not the ones who have qualified before 2001, not the ones who have entered service. My lords may have reference. Same thing has. My lords, except for that, except. My lords, just one thing, the reference, if my lords have, we've uploaded an order of the Honorable Bombay High Court. My lords may just have that order. My lords, this is Bombay High Court. My lords, 29th July 2027, the Honorable Bombay High Court relies on this para 168. I just want to read out those 2 pages. My lords, has the document titled order in reference. My lords, has the order. I'll just read those 2 lines after that.
Are you telling it constitutional?
Precisely, my lords, that after the Supreme Court order, the state government does not have the authority to predate this or abolish this cutoff of 3rd September. My lords, has the reference. My lords, this is Honorable Division Bench, 29 July 2026, Bombay High Court. My lords may have para 3. There are 6.
Clear the examination. What is the problem?
My lords, I understand. If
You are teaching this
we will,
subject in class 30 years.
we will, my lords. We are before my lords. My lords may just read one para. This is the para 6. All such teachers whose dates of appointment are prior to September 2001 shall stand exempted from passing TT examination in accordance with the directions contained in the decision of the Honorable Supreme Court, which my lords read. And then the Honorable Bombay High Court quotes 168. Para 6 at page 2, bottom of the page. This is the Bombay High Court order I am referring to.
Sir, they are conducting an exam. If suppose interim order is granted and you don't appear in the exam, and ultimately your position gets dismissed, you will not get chance to appear in the
My lords, this is clear.
So you will have to appear.
The Honorable Bombay High Court
Whether it's
also.
clear or not, that will consider
My
later.
lords, we are not even.
Because this is a one-time examination.
No, my lords, it has to be conducted every year. This is NCT within 2 years of the Honorable Supreme Court. No, my lords, they filed a review. That review also decided on 29th of May 2026. Please, my lords.
Whether that clarification is there.
No, because nobody sought it. It is clear. Bombay High Court relies on it, saying that.
Okay, but we are not. We are not bound. According to us, the confusion part is everybody agrees.
Except
your result subject to final outcome, you consider it. It is choice. If you don't want to appear, don't.
if my lords are issuing notice in this. In that case, my lords, I have one suggestion. Let the state come back because 12th October is still far away. We have a month and a half. Let the state come back. Maybe my lords can have it in end of September, and we may be able to persuade. Let the state also give its opinion, because even in the notification, there is not a word about para 168. State government filed a review. That review also is dismissed along with everybody else. In fact, our hope is what my lords in Indore had. Deeply obliged.
I sincere apology. Lordship may give some returnable date in that. Some returnable date in that matter.
4 weeks.
2 weeks.
Immediately after service.
सर्विस हो जाएगी तो लग रहा है तो रजिस्ट्री नहीं उठाएगी पेंडिंग में इतना लेक्चर अच्छा नहीं लगता तो रोज मेंटेन
रिटर्नेबल 2 वीक्स करते तो वो आ जाएगा। भोपाल में तो है सर्विस करा
वो डेली सर्विस तो करते हैं
माइलर आईए नंबर 20261/2026 में। माइलर आईए नंबर 20261/2026 माइलर।
हाँ ये बताइए क्या है
मैंने अनेगर आईए नंबर 1 माइलर, पेज नंबर 6 माइलर, इसमें 16/7/26 को माइलर ऑर्डर हुआ था कि 1 स्टॉप में 3 मंथ के लिए रखा जाएगा। तो लड़की अब माइलर घर जाने के लिए तैयार है, मेडिसिन काउंसलिंग हुई थी माइलर। तो अनेगर आईए नंबर 3 पेज नंबर 11 माइलर टाइप होती है जी माइलर।
लड़की कहाँ है अभी?
लड़की 1 स्टॉप में है माइलर,
कहाँ पर?
पन्ना छतरपुर, पन्ना छतरपुर
कोई लेटर भेजा कर लिख के हमको नहीं रहना है
आप किसकी हो?
जी माइलर। पेज नंबर 11 माइलर आईए नंबर 3।
आप कौन है
लड़की खुद लिखे
कौन है लगाइए
माइलर, पिताजी ने उनके आसिफ प्रसाद। पेज नंबर 11 माइलर टाइप कॉपी, माननीय उच्च न्यायालय जबलपुर द्वारा बाल कल्याण समिति पन्ना मध्य प्रदेश। निवेदन है कि मैं अपने माता पिता से गुस्सा होकर घर के से चली गई थी, जिसकी रिपोर्ट थाना अमानगंज में की थी, तथा मुझे वापस आने के लिए आपके यहाँ प्रकरण दर्ज 27/515/2026 करवाया था, जिस पर आपने आदेश देते हुए मुझे 3 माह तक 1 स्टॉप सेंटर पन्ना में रखने का आदेश दिया है। निवेदन है कि मैं कक्षा 10 में पढ़ रही हूँ, कन्या पाठशाला अमानगंज में पन्ना की दूरी 35 किलोमीटर है, जिससे मेरी पढ़ाई प्रभावित होगी। अतः मैं अपने माता पिता के साथ घर जाना चाहती हूँ और मेरे माता पिता भी घर ले जाने के लिए तैयार हैं। अब मैं ऐसी गलती दोबारा नहीं करूंगी। निवेदन है कि अपने आदेश पर पुनः विचार करते हुए मुझे मेरे माता पिता के साथ जाने का आदेश देने की कृपा करें, तथा मुझे भूल सुधारने का एक मौका देने की कृपा करें।
उसको बुलवा लेके पूछ लेते हैं जाना चाहती तो भेज देंगे फादर।
तो 1 स्टॉप वाले माइलर ये बोलते हैं कि उच्च न्यायालय से आदेश आएगा तभी मैं जाने दूंगा।
Malad, just now he got it listed, this case, we don't have record. Malad, we keep this matter next week, we'll keep present the corpus.
रक्षाबंधन हमारे इसलिए ठीक हो जाएगी कल से, मुझे रक्षाबंधन में घर जाना चाहती है लड़की।
तो अब एक दिन भाई बोल रहे हैं तो भाभी जी तो उनकी नंबर लगाया
इसको लगा इसके पास 42 नंबर कैसे नहीं किस सीरियल में
42
कहाँ है 42 Malad, में पास है
लोकल मजिस्ट्रेट का बयान है
CC to the
I was connecting the corporate to the one-stop center for the period of 2 years. The CWC Panna was directed to Congress of Council. I filed an application. People calling of the order in the ground that now she is able to require the service. That is the one-stop center is practically able to offer the paper. Local magistrates, detail report are open and thereafter they will be willingness to go along with the party to the conversation.
CC2D माइलर, CC2D माइलर।
क्या करोगे इतनी जल्दी हो रही है एक पे नजर है ना दोस्तों वहाँ दिमाग सुधारना है चलिए
Item number 17.
The only question here is whether whether a colony can be established over a Nazul land or not. Nazul land, my lord. And which is given on lease, my lord. It is like, my lord, Satyamev Jayate Parisar and the entire civil line, my lord. Everything is on Nazul land, and my lord, there are on lease land, my lord, the colonizations have taken place. My lord, what happened was, my lord,
For how much? 30 years.
30 years, my lord. It is from 26, again 30 years lease is there, my lord.
What is the condition of lease?
Condition of the lease was not under question, my lord. It was that, my lord, that I secured all the permissions.
For commercial purpose.
My lord, for residential, my lord, all the projects in civil line, everywhere, my lord, it is in the Nazul lease. These rights are, my lord, transferred. Like in MP Housing Board got a Nazul land, my lord, here, just opposite to High Court, my lord, Satyamev Jayate Parisar. On that leased land, my lord, they have constructed a colony, my lord, buildings, and they have also leased it out.
That purpose was known to the government.
That is known to the government that it is permissible.
Government
No, my lord, it is permissible also, my lord. I secure
what is the condition? Why the land was given to you on lease?
No, my lord. Initially in 26, it was given to one Mishra family, my lord. And they continued to stay in possession of that land, my lord. In 27, a Fat Batan, that a partition took place between the family. The land was sold to various persons, my lord. The land was sold to various persons, my lord. Lord, sir, kindly hear me for 2 minutes, my lord.
Original lease was given in 1926 for residential purpose.
So it's a residential purpose only we are using, my lord. We are not using it.
The collector says that the lease was given
Let
for a
me complete.
residential purpose.
Let me complete, sir. My lords, may come to page number 90 for a moment, my lord. 90. I'll take, my lords, for 2 or 3 documents, my lord. If my lord is satisfied, paper book, we had submitted paper book also. पेपर बुक सब जमा कर दी थी, my lord.
अरे जमा यही देना है। तो मांगेंगे आपसे रेफर करने के लिए, बाकी लिखना तो रेफरेंस
नहीं, रेफरेंस तो है,
फाइल कर दीजिए आप।
फाइल कर दी।
इस फाइल करके थोड़ी बोलो।
मैं सिर्फ इतना सा, my lord, पेज नंबर 90 देख लें, रेफरेंस में है भी, पेज नंबर 90 ऑफ द पेपर बुक, my lord, 90। कलेक्टर को यह कंफ्यूजन था कि नजूल लैंड पे अगर कॉलोनाइजेशन की परमिशन दी जा सकती है कि नहीं। He went up to state government. State government said कि under the Nirvartan Nirdesh 2021, my lord, the provisions are there. A note was called from additional collector, my lord, which is at page number 90, my lord.
You are referring page from petition or
From this
covering memo, my lord?
covering
Number
23. 23 in ERP. वो स्कैन करते हैं अपलोड 90 इसका कौन सा पेज इस पे it's P13 annexure is P13 pages 90. This is a document dated, my lord, 24/12/24. My lord, this is, so he wrote to the additional collector, my lord, last paragraph of this letter, my lord, at page number 90. मध्य प्रदेश नजूल निर्वर्तन निर्देश 2020 के परीक्षण में पाया गया कि अध्याय 3 स्थायी पट्टे नजूल भूमि निर्वर्तन भाग 6 स्थायी पट्टे का नवीनीकरण प्रक्रिया के अंतर्गत कंडिका 83 में आवासीय भूखंड की भूमि का परिवर्तन संबंधी उपबंध प्रावधानित है। कंडिका 83(1) के अनुसार आवासीय भूखंडों का पट्टेदार पट्टावधि के दौरान
भी या नवीनीकरण की प्रक्रिया के दौरान भी पूरे या अंश भाग पर भूमि का उपयोग का परिवर्तन कर सकता है। कंडिका 83(2) के अनुसार सक्षम प्राधिकारी प्रश्नाधीन भूमि को तत्समय प्रचलित मास्टर प्लान के अनुमत प्रयोजन के अनुरूप और अन्य प्रचलित विधिक प्रावधानों की अनुमति रहते हुए प्रयोजन परिवर्तन शुल्क प्रावधी और वार्षिक भूभाटक आने वाली अंतर की राशि जमा कर भूमि का उपयोग परिवर्तन की स्वीकृति दे सकेगा। 83(3) के अनुसार सक्षम प्राधिकारी द्वारा प्रयोजन परिवर्तन हो जाने की स्वीकृति जारी होने पर पट्टे की शर्तें स्वतः सीमा तक संशोधित मानी जाएगी। तदनुसार आवेदक संस्था द्वारा प्रश्नाधित भूमि के आवासीय प्रयोजन के लिए व्यवसायिक प्रयोजनार्थ परिवर्तन कराए जाने की स्थिति में तदनुसार पट्टे की शर्त में हुए स्वतः परिवर्तन के अनुसार विकास की अनुमति दी जा सकती है। Now he gave second option also that if you want, you can get this land also turned into a freehold land. So this is permissible, my lord. Now page number 93, my lord, the collector passes an impugned order. The relevant portion is at page number 95, my lord. 95, last paragraph. इस प्रकार उपरोक्त परिस्थितियों में स्पष्ट है कि प्रश्नाधीन भूमि नर्मदापुरम के नगर में नजूल भूमि है, जिसका प्रत्येक 30 वर्ष में नवीनीकरण किया जाना है। वर्तमान में नवीनीकरण भी मार्च 31-25 तक की अवधि का है। नाउ इट हैज बीन एक्सटेंडेड फॉर नेक्स्ट 30 इयर्स, my lord. यह भूमि मध्य प्रदेश शासन द्वारा 30 वर्षीय लीज पर आवासीय परियोजनार्थ मूल आवंटी गया प्रसाद मिश्रा को 1926 में आवंटित की गई थी। मूल आवंटी की मृत्यु के उपरांत उसके उत्तराधिकारियों द्वारा भूमि को विक्रय किया गया है। क्रेताओं द्वारा उसका प्रयोजन आवासीय से व्यावसायिक परिवर्तित कराकर उस पर आवासीय कॉलोनी का निर्माण के उद्देश्य से नगर तथा ग्राम निवेश में आवासीय न्यास को अनुमोदित कराया गया है। मध्य प्रदेश नगर पालिका कॉलोनी नियम 2021 में नजूल भूमि पर आवासीय परियोजनात्मक, दिस इज द क्रक्स, मिलो, आवासीय परियोजनार्थ कॉलोनी विकास की अनुमति का स्पष्ट प्रावधान नहीं है। साथ ही मध्य प्रदेश नजूल निर्वर्तन निर्देश 2020 में भी नजूल भूमि पर कॉलोनी के निर्माण संबंधी अनुमति के दिए जाने का प्रावधान नहीं है। ऐसी स्थिति में आवेदक संस्था द्वारा now he cancelled it, my lord. My lord, I have got TNCP which says it is residential land. I can do it, my lord. I have got Nozul NOC also, my lord. I have got all other NOCs available. But for, my lord, Rule 10 of colonizers rule in municipality, in which the collector is the competent authority to give yet another NOC, my lord. Here we got stuck up because the collector initially, my lord, she was, my lord, of the opinion that there are no clear, my lord, instructions, despite there being clear instructions, my lord. We came to this honorable court, my lord, we filed the petition stating that only Rule 10 application is pending, my lord, and that should not have been turned down on this ground. Now, once the petition came, my lords, may come to page 20 of this compilation, my lord, 20. Could my lord see? My lord, come page number 20. Page number 20, my lord. That is the order dated 7th of April 25. In this, my lord, the controversy was, my lord, whether on a Nuzul land, paper book 20, my lord, paper book 20. Page 20. कामाख्या एफिडेविट उसके एग्जैक्टली बाद में लॉर्ड आवेदन कब होगा आवेदन पर आवेदन का कुटुंब सदस्य बंटवारे का नाम आता है ये पेज 19 पे शुरू हो रहा है ये अपलोडेड भी नहीं है लॉर्ड डब्ल्यूए के पेजिंग से बता डब्ल्यूए के पेजिंग से लॉर्ड Your petition has been written without notice. My lord, no, notices were issued, my lord, and there it was held, my lord. Page number 6, page number 5 onwards, my lord. The controversy was, my lord, whether on the Nazul land permission cannot be granted. However, the first paragraph at page number, internal page number 5 of the order, my lord, no document has been filed and placed on record by the petitioner to show that the leasehold right have been acquired by them from the aforesaid leaseholder. My lord, it is only the leasehold rights which are transferred. The collector in the impugned order dated 26/12/24 has mentioned that the petitioner firm has purchased so and so land by registered sale deed and mutation has also been done in their favor. Lessee does not have any right over the land in question and they have only right to enjoy the property till validity of lease. Therefore, the land could not have been sold by registered sale deed to petitioner without there being any clause of sublease. Lessee can sublease the land in question if the lease agreement permits to do so. Lessee, as per lease dated so and so, has right to hold enjoy the land during the term of the lease without any lawful disturbance for the lessor. The same right has been passed by the lessor in permission of the lessee or if the lease deed specifically provides for it. No condition in the lease has been pointed out by the petitioner that the lease right has to sublease or sell the land. Any document showing the permission from the lessor is filed before the court to show permission was obtained before subleasing or doing registered sale deed of the land in question. In view of the same, the petitioner does not have right to file application for development of colony. The lease has already come to an end on 31/3/2025. No document is filed to show the same has been renewed. The state government by notification dated 20 has superseded revenue book circular number so and so. The petitioner is at liberty to comply with the provision of Madhya Pradesh Nazul Bhumi Nirvatan and get the plot converted into freehold and thereafter develop the colony. My lord, that was nobody's case, my lord. Now thereafter, my lord, we came into writ appeal, my lord. We filed a review application, my lord. With the review, we said that not only that, we have also got the lease renewed for next 30 years, my lord. Now, my lord, the review application was dismissed on the count, my lord.
You are a purchaser or
My lord, leasehold rights have been purchased. I applied for renewal. The renewal has been granted in my.
when was applied by the original lessee or
By us, my lord, after, because this lease was a fund. My lord, we purchased.
As per High Court order, you purchase the property with 6,000 square meters.
Square meters of.
You purchase the property from the
Lease property, leasehold rights have been purchased, my lord. Not leasehold right. क्योंकि उसके बाद भी हमने लीज के रिन्यूअल के लिए अप्लाई किया. अगर हम प्रॉपर्टी पूरी फ्री होल्ड टाइप की खरीद लेते तो लीज अप्लाई नहीं करते. लीज राइट के लिए किया, लीज भी रिन्यू हो गई. फिर हम रिव्यू में आए कि हमारे फेवर में लीज रिन्यू हो गई है एंड जो निर्देश नजूल निर्वर्तन निर्देश है, दे ऑल्सो परमिट दिस दैट दीज कंडीशन कैन बी चेंज. जब आए तो उसको बोला कि यू फाइल an application and establish your right before the civil court, which was nobody's case, my lord. Thereafter, we came before this honorable court, my lord, in writ appeal, my lord, on the very first date. This honorable court was kind enough to, my lord, observe the army leasehold right kharidega, so he can use it. My lord, like and we had placed on record in writ petition itself, my lord, permissions of at least 5 districts, Chhindwara, where Nazul land was permitted, Bhopal, Jabalpur and other places, that this can be done and it has been done, my lord. The entire civil line is on lease, my lord. It's all on Nazul lease. Half of the right town is on Nazul lease, my lord. Half is on municipal lease. Everywhere this can be permitted, my lord. And as per rules, it is permitted. Now, once faced with this observation, my lord, that why it would be useful, they opened up a case of 2007 partition ka.
Yes.
A colony, residential colony, purely residential colony. कोई उसमें कोई commercial वो नहीं है. It's a residential colony, my lord. और सारी sanctions हैं हमारे पास. सिर्फ this was in relation to Rule 10 of.
Suppose after 30 years or before 30 years, government cancelled or reduced the land, then every purchaser of house will.
No, my lord, सारी जगहों पे all, my lords may see the entire. It is leasehold land, my lord. Even this MP Housing Board takes the land on lease from the government, and these leases are renewed thereafter by the government itself, my lord. And this is perpetual lease, my lord. Since 1926, the leasehold rights are there with them. It is not a new lease, my lord. But 30 years is the limit, my lord. 30 years के अंदर renew भी कर दी. अब उसके बाद collector got offended, my lord, with this observation. तो उनने एक permission seek करवाई कि to review the order of 2007 जहाँ पे family partition हुआ था. After almost 40 years. उस पे उनने condition ये बोली कि जो नजूल ऑफिसर था जिसने partition किया, he had no authority. और वो भी जब डिसाइड होने आया तो उनने ये इसके ऊपर कुछ नहीं डिसाइड किया. And this is in contravention to, my lord, the full bench of this honorable court, my lord, regarding 180 days of suo moto review and revision, my lord, in MPLRC.
Nazir order is dated 21/4/26.
26, my lords, may come to page number, my lord, 463. 463. इससे पहले भी, my lord, जब ये सब हुआ था, they sought permission. This honorable court was kind enough to pass interim orders to the effect that if you want to review, you review, but if the adverse order is passed, it would not be implemented. Now, my lord, 463, my lord. My lords could get it, my lord? 463. My lord, the last three lines of first paragraph. इस प्रकार पारिवारिक व्यवस्था पत्र के तहत बंटवारा किया गया है, जबकि नजूल अधिकारी को संहिता की धारा 109-110 में तहसीलदार को नामांतरण की शक्तियां थी. This was the reason on which, my lord, the permission was granted and accorded, my lord. और next page पे 464 पे वो permission लगी हुई है. Now at 487 the second impugned order is there, my lord. Well, वही सब कुछ रिपीट किया उसने, my lord. They got annoyed. No, my lord, ये 100 पेज ऑर्डर तो रिव्यू का है. इनने अभी तक ये हमने तो जमीन बेची, ये 3-4 भाई थे, सबने अपनी अपनी जमीनें बेच दी, वो आगे भी बेच दी, सब पे बन गया. तो सबको इसने बुलवाया, वही सारे कंटेंशन इनने रिपीट किए पूरे उसमें बार बार. एंड देन, my lords, में काइंडली सी पेज नंबर 524, my lord. 524. इनने रिव्यू की परमिशन इसलिए मांगी थी कि नजूल ऑफिसर के पास परमिशन अथॉरिटी नहीं थी. अब पेज पैराग्राफ नंबर 57 में लोग उपरोक्त विवेचना के आधार पर आवेदक अधिवक्ता द्वारा पारिवारिक व्यवस्था पत्र के विभाजन पूर्व में ली गई नामांतरण की अधिकारिता के संबंध में उद्भूत प्रश्न तब लागू होंगे जब पारिवारिक व्यवस्था का सद्भावनापूर्ण स्वैच्छिक भागीदारी और सर्वसम्मति से स्वीकृत और आधारित सिद्ध किया गया है. प्रस्तुत प्रकरण में पूर्ण अवलोकन में पारिवारिक व्यवस्था पत्र के आधार पर खाते का विभाजन बंटवारन की अधिकारिता.
तो वो पार्टीशन कैंसिल कर दो.
इसने ये बोला कि सर पहले तो ये बोल दिया इनने कि ये तो इशू ही नहीं है कि वो अथॉरिटी है कि नहीं. लास्ट 2 लाइन्स में लौट में सी. अतः आपसी पारिवारिक व्यवस्था पत्र दस्तावेज के आधार पर खाते के विभाजन एवं नामांतरण की प्रविष्टि अंकित करने की अधिकारिता संबंधी प्रश्न पर विचार किए जाने की आवश्यकता प्रतीत नहीं होती. इसने इसलिए लिया. और 2007 का 2026 में
इस ऑर्डर का क्या करें?
इसको भी चैलेंज किया. आई फाइल्ड अ सेपरेट पिटिशन एंड द ऑनरेबल डिवीजन बेंच वाज ऑफ द ओपिनियन कि चूंकि हमने स्टे किया तो एवरीथिंग वुड लाई हियर, तो देन वी चैलेंज हियर.
अभी इफेक्टिव नहीं है
और ये इफेक्टिव भी नहीं है. ये ऑर्डर भी इफेक्टिव नहीं है. ये ऑर्डर भी उसने लिखा है पेज नंबर 528 पे. अब नहीं हम तो ये भी चैलेंज किया यहाँ पे, क्योंकि अब ये तो this my lord, this writ appeal I was, my lord, I filed a separate writ petition on that ground that as per full no, my lord, वहाँ पे ये बोला गया कि you file application here in the pending writ appeal only because there is an interim order which says that this order would not be given effect to 525 पे आ जाए, my lords. इसी पेपर बुक की पेज नंबर 525
इनको मिश्रा, आलोक मिश्रा, अमिताभ मिश्रा, इनके नाम को
525 लास्ट पैराग्राफ। चूंकि वादग्रस्त भूमि के संबंध में माननीय उच्च न्यायालय मध्य प्रदेश जबलपुर में प्रचलित रेट अपील क्रमांक सो एंड सो के विरुद्ध मध्य प्रदेश में अंत में पारित आदेश दिनांक 11/2/2026 दैट इज द इंटरिम ऑर्डर पास बाय दिस ऑनरेबल कोर्ट में लॉर्ड, में ये निर्देश दिए गए कि यदि प्रस्तुत पुनरावलोकन प्रकरण में आवेदक क्रमांक 6 कामाख्या देवी एसोसिएट्स के प्रतिकूल कोई भी आदेश पारित किया जाता है तब उक्त आदेश का क्रियान्वयन माननीय न्यायालय द्वारा नियत तिथि के पूर्व न किया जावे। अतः एंड दिस thereafter, my lord, an interim order was granted to us, which is continuing till date, my lord. So we were left with no other option but to challenge it here, my lord. That was there. We had filed a separate petition, and then we had withdrawn it also, my lord, on the count that everything is pending here. My lord, this is where, my lord, an administrative authority who got annoyed and resulted into all this. This is simple question was, my lord, whether this could be done or not, my lord. It is permissible under law, number one, my lord. नंबर 2, सिर्फ हमने नहीं बेचा, बाकी ब्रदर्स ने भी बेच दिए थे अपने से, वो यहाँ सामने नहीं आए थे। और नंबर 3, जिस कारण से इनने रिव्यू बोला, सुमोटो रिव्यू लिया, उसको तो उन्होंने ऑर्डर ही दूसरी तरीके से कर दिया। पैरा नंबर 57 में उन्होंने बोला इसकी जरूरत ही नहीं है। अब नई चीज के ऊपर इनने ये बोल दिया कि आपने जो बंटवारा करवाया था, Milord, Milords may kindly come to order it. नहीं, उसकी आपत्ति डिसमिस कर दी। नहीं, वो कोई था ही नहीं, ये इस फैमिली का नहीं था। मिलोड, यही अथॉरिटीज तो हमारी तरफ नहीं थे, तभी मिलोड में कम टू ऑर्डर डेटेड 11/2 मिलोड, फेस विद ऑल दिस मिलोड 11/2/26 मिलोड। लास्ट पैराग्राफ मिलोड में करनी थी। We know, page number 2, my lord, we note that the proceedings are still pending before the noodle officer pursuant to suo motu review order being passed on 25/7, and the proposal of review of the said order is also pending. We direct that the noodle officer to conclude the proceeding after giving opportunity of hearing to appellant and also taking into consideration the मिलोड 2007 का कैसे करेगा मिलोड? नंबर 1 अब मिलोड स्ट्रेट अवे इट इज हेड बाय फुल बेंच ऑफ दिस ऑनरेबल कोर्ट मिलोड, और उसमें इफ इन केस मिलोड वी हैव चैलेंज दिस इन दिस पिटिशन ओनली, वी फाइल्ड द सेपरेट पिटिशन एंड वी वर टोल्ड मिलोड यू चैलेंज इन दिस ओनली एंड सो दिस इज द आईए। और ये ऑर्डर इफेक्टिव भी नहीं है सर अभी तक। ऑर्डर है पर इफेक्टिव नहीं है मिलोड। मिलोड रेवेन्यू अथॉरिटी से ही तो प्रॉब्लम थी, यही हमने तभी बताया था कि डेलिबरेटली जब वो वहां पे उनके पास कोई केस नहीं बचा तो सुओ मोटो रिव्यू में आ गए, और रिव्यू में एक कारण से परमिशन ली, दूसरे कारण से
आपके अलावा बाकी 30 लोग अफेक्टेड भी हैं ऑर्डर को।
मिलोड किसी को कोई दिक्कत नहीं थी मिलोड, कभी किसी को कोई दिक्कत नहीं थी, पूरी फैमिली को दिक्कत नहीं है। एक फैमिली से पहचान के किसी ने ऑब्जेक्शन लगाया है इसके ऊपर, फैमिली को भी दिक्कत नहीं है, फैमिली वाज हैप्पी, फर्द बटांकन था, जो जिस हिस्से पे बैठा हुआ था एवरीबॉडी टुक देयर शेयर, दे सब्सिक्वेंटली सोल्ड देयर शेयर्स मिलोड, ओनली जस्ट बिकॉज अ कलेक्टर वाज नॉट विद अस मिलोड and he got confused मिलोड, the entire thing got stuck up. Now the collector has also changed. Milords में
all parties are before us. All parties in this party. Because it's they are not telling me they are satisfied with this order. These are difficulties.
Milord, 2 are extended. Milord,
you are agreed. Other 30 are not are before us. There is no notice to them. That means they have accepted this order.
Milord, they have some of them. Milord, some of them have challenged before the SDO as well, Milord. That is no, Milord. Some of them have challenged before the SDO.
Go and get notified, then
Milord, kindly bear with us, Milord. कुछ कोई लेना देना नहीं था, just because of fight with the government. My lord, nobody should fight with the government as first thing, my lord. But my humble submission, my lord, let everything be sent to collector. Now the collector has changed, thankfully, my lord. The old one is. my lord, सिर्फ छोटी सी चीज हम आपको एक सिर्फ ऑब्जर्वेशन दे दें कि जो हमको भी इसको चैलेंज करने के लिए एक परमिशन दे दें और एक फिक्स टाइम दे दें इनको डिसाइड करने का कि वो आपको लगाना पड़ेगा, हम लगा देंगे 15 हमको हम 4 दिन में लगा देंगे, 15 दिन में वो डिसाइड कर दे या 1 महीने। सर वी हैव गॉट वेरियस लोन्स ऑन आवर हेड, my lord. This is a classic case where, my lord, just because one collector got annoyed with us for approaching the authority of this honorable court, my lord, all this humbug has come into. My lord, the basic thing is, my lord, after a pass of 25 years, my lord, there's a direct full court which says he could not have reopened it. This was also observed by this court, my lord. वो order देखेंगे और उसके बाद उन्होंने बोला था ये effective नहीं होगा, तो this order is also not effective till date, my lord. That interim relief continues. Interim order, but that order has been passed now. Now, my lord, may give us that liberty. My lord, 15 days time, everybody is there, my lord. 15 days time. क्योंकि हमारे पास 5 साल से हमारे लोन्स चलते हैं, हमने पूरा पैसा लिया हुआ है. We can consider, but now technical problem. My lord, only one thing, my lord. Within a month's time, they may be directed to decide this issue, my lord. And we will be permitted to come before this court after that. So, pending question आपकी रहेगी. My lord, पर observations जब तक नहीं होंगे तो टाइम कर देंगे. एक छोटा सा ये क्लासिक केस है how a person can be, my lord, put to all adversaries, my lord, just because one collector thought that we should not have approached the authority. Nothing was there. सारे भाई बहन खुश हैं 2007 से, सबने अपनी जमीनें बेच दी, सब कुछ कर दिया. जिस इशू पे आपने रिव्यू मांगा था वो इशू पे आपने बोल दिया हमको कुछ नहीं बोलना है अथॉरिटी ऑफ नजूल ऑफिसर की, क्योंकि 178 within a limited time frame, my lord, and then
But I'm only making a humble request, my lord, because of the urgency involved in item 20, my lords. My lord, ये matter, your lordship listed it for 19/8, my lord. My lords were not available. Therefore, the matter got listed before the coordinate bench, and the court directed that the matter may be listed today. But this is a tender matter, my lord, and interim order has been passed against us, my lord. Your lordships directed that it will be heard finally at motion stage, and your lordships. Sir, 20 number पे है sir.
23 से interim order.
Yes, ma'am. नहीं 20 में sir interim order. Your lordships. So the on 27/7/2026, my lord, your lordships directed that. Sir, WP number 28517 of 2026. Sir, 27/7/2026 का जो आदेश है, उसमें वर्क ऑर्डर नहीं इशू करने के डायरेक्शन हो गए थे.
This is a matter pertaining to aquarium, my lords. जिसमें
Sir, the Bhopal aquarium issue where I pointed out, my lord, and your lordships directed that since if there is anything wrong, then we will also impose exemplary costs on the petitioner, my lord. The pleadings are complete, my lord. Sir, Nivedan, my difficulty is that my client, my lord, but my lord, my client.
Government बाकी केस में अभी हमारे पास पैसा नहीं है, छोटे-छोटे petty contract.
I bow down to your lordships on that.
एक्वेरियम बनाने के लिए करोड़ों रुपए.
My lord, I'm for the private bidder, my lord. I'm for the successful bidder, my lord. That department is being run by anyone else. My lord, any fixed date may be.